Good morning. Or should I say, hear ye, hear ye, hear ye. Welcome to Live Trials with Emily D. Baker, where I cover trials gavel to gavel with live commentary, breaking down the evidence, the strategy, what all the legal jargon means, and sometimes just being absolutely flabbergasted like I was yesterday. But today's a new day. It's day 26. It's Tuesday, June 3rd. Dr. Russell's on the stand for cross-examination. I imagine it will be a somewhat lengthy cross-examination based on what we've already seen from prosecutor Hank Brennan. And I think Brennan probably feels like he scored some hits yesterday, so he's not going to just stop. He's got a whole different demeanor yesterday in his cross. We'll see what today's demeanor is like. Hopefully court will just, I don't know, run kind of smoothly today. Who knows? We're like day 3 into the defense case, and stuff has already been incredibly unexpected, and I guess that's what I should expect with this case, is that nothing is quite normal. We should just expect the unexpected at this point. So, Law Nerds, are you ready? Let me know where you're coming in from. Let me know what you're drinking. Replay crew, as always, everything will be timestamped down below, so if there's just moments you want to see in court, those will be down below, and if you're like, girl, I've got things to do, look, I get it. We're in week 7. It's a lot of court days. The Law Nerd app will tell you when stuff pops off, when witnesses change, etc. So we'll keep you in the loop so that you can also get stuff done. We've got you. No, don't worry. There's some witnesses you're like, nah, I'll be back later. It's fine. We'll just let you know in the app. So make sure that you have it. All right, let's go to court. Well, let's roll the intro and then let's go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the Law Nerds in the chat. They're here for the facts, not and let's get to court. I feel like I should also give like a disclaimer. Cats will interrupt, and my cats will interrupt, because already this morning, George is just like doing all the things. He's ready. But you know who else is ready? We're ready. It's good to see everybody. I know it's getting warm where you guys are. It's getting warm where I'm at too. I feel you. We're going to have to turn my fan on in a minute because it's already warm in the office, which is spicy. I need the closed caption so I can move them. All right, court. I don't want to miss the hearings. We had queued up right to the hearings. Queued up beyond the hearings? No. We've got to be almost there. I was going to say.
Anything to do before the
I'm just trying to move the closed captions. Come here.
Superior Court. Holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Exactly. We need the hearings.
Good morning,
it's the only court I know that does them, and I enjoy them.
Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow my
same little questions.
Discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the
Those same little questions.
Doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should get. Is Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
Okay, we're going to zoom past waiting for everybody to walk in, because we don't need to wait for everybody to walk in.
Doctor, I'll remind you, you're still under oath.
We're going to get back to Dr. Russell on cross-examination.
Yeah.
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who
said that.
helped
Formatting.
me or made suggestions in organizing the report,
Yeah,
having
someone
certain
helped you.
sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
I'm sure it's her report. Brennan, are you approaching? Are you not approaching? Are you slowly? Oh, Emily, be fair. He's got to go show it to Alessi. That's fair.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
And I said, okay.
That's what she said.
And you answered.
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Alessi.
Okay.
And Mr. Alessi, is that gentleman the attorney who asked questions
He
on
asked her that directly
direct
yesterday,
examination?
and she said
Yes.
it wasn't Alessi.
And so, did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
testified to. You want to
Yes,
see it again?
yes.
Okay. By the way, between last night
She's asking
and
to see
today,
her reports a lot
did you get
more.
any advice
I was going to
from
say.
anybody suggesting you should
Ask to
ask
see
for
your
a
reports.
transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night
What?
that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
You
So you and
can't
Mr.
talk
Alessi,
to
you know there's a
counsel.
sequestration order, don't you?
What?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the
didn't. We didn't discuss specifics.
You discussed
You
how to
know that the
testify.
sequestration order mandates that you not discuss anything about the case
You can't discuss
from when
how
you
to
start your
testify
testimony until you end your testimony. You
at
know that,
all.
right?
That's not appropriate at all.
understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys,
That is
about
a
this case
bad
overnight?
look.
Did you
Alessi
understand
knows
that?
There
better.
were no specifics discussed.
Well, did you understand that you weren't supposed to, is what I'm asking. Did you?
You can't talk to them about your testimony. It doesn't matter if there's specifics or not specifics. Hey, you should ask for a report. That's talking about your testimony.
know that's a violation of the sequestration
No, I
order
did not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
He should.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
I don't like it.
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday, no.
When
Not in the car yesterday, no.
did
Well,
you have
said
this
that you
conversation
spoke to
then?
Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order
mess.
that you're under?
This morning, riding to court
Okay, so
You
and
talked
Attorney
this
Alessi drove to
morning.
court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about
Yeah,
this case.
that's not.
Just that I should
At
ask for
all.
a transcript.
That's not
Well, there must have been
okay.
some concept. There must have been some context. He didn't just turn to you talking about the weather and say, "Hey, you should ask for a transcript."
knows
He must
better.
have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he talk? How did it come up? Hey, by the way, ask
I-
for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
May I approach?
Yes.
Ma'am, you're an expert witness. He's allowed to ask it. He's allowed to ask
If
it.
you've asked for the
Her
transcript,
reaction
I'll ask
is not
for you.
appropriate for an expert witness. He's allowed to ask the question. She did gasp at memory issues. He's allowed to ask because that was her gasp, but it was way, way too spicy because she is there as a paid expert. This is not a good look for her. He is allowed to ask it. It's just wild. I know all of you are saying it's rude on him, but if the defense asked it of somebody, you wouldn't feel the same way. I get it. He's allowed to ask it. She isn't supposed to be having conversations overnight. There are things that she is doing that she should not be doing at all. And she should not be doing any of this. So I'm not surprised by his questions. I'm really not surprised by his questions at all. She's an expert witness. She's beginning to be evasive. And now they're talking about how her testimony should go, and he's allowed to ask her about it. And the fact that she is being taken aback is different. But when witnesses are evasive, they get asked that all the time. And we've seen it in this case. Do you have problems? Oh, so you're not remembering this. Okay.
Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
She said that, though.
That looks consistent.
You want more time with the transcript?
No.
She said that. Alessi shouldn't have talked to her at all. And Alessi should know better. Because again, I don't
anybody
think
else talk to
she's
you
going to
about
try
your
to do
testimony
anything
today
that she's
overnight,
not supposed to
Dr.
do.
Russell?
She doesn't
No.
know. She does not do this regularly.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
That's what she said.
On that same date?
Yes,
May I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach. Objection, Your Honor.
I'm going to strike that.
Yeah.
Disregard that, Joyce.
The
Yeah,
commentary,
Yes.
Brennan.
Did you want us to-
23. June 21st,
I don't think Brennan's pissed. I think Brennan sees that this witness is getting
23.
pissed.
Line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you.
That's the same, though. He's like, you said you weren't 100% certain it was a large dog, but you said it was possibly a large dog. Like, what in the world?
When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination,
Right.
there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes?
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
when you describe methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance,
'Cause it's more dynamic
how to
than that.
determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential
You guys have a lot
diagnosis,
of good
the pattern
questions. I'm holding on to
Pattern
them.
recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source. There is no recognized community. There's no certification. There is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the
Right,
thousands
'cause
of different
there's
types
too
of
many of
abrasions.
them.
So no, there's no published standards.
No published standards.
Right, we know that.
There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday
He needs to move
is
on
a
with that.
readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how
Right.
to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an
audio just
approach
changed, which was
to identifying,
weird.
particularly a forensic approach to identifying dog bites.
Let me
Right.
ask you the question again, Dr. Russell.
She answered it.
Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick, and the
He's
article
just
with the
trying
lead
to get a different
author of
answer
Dr.
by
Pollack.
wearing her down.
And
Which
although
I think
they're
he
not
rattled her this
standards,
morning,
they
and
are
he thinks
recommendations.
he's going to get some headway on that.
I'm
I
going
don't
to
think
ask
he
you the
will.
question one more time before I approach. Can you point to one place, one,
I mean, she just
where
answered.
there is a readily accepted standard in the dog bite community for identifying dog bites?
The limit does not exist. There is no
No.
dog bite community. It's a medical community.
And so with no readily accepted standards in the dog bite community,
Oh, it's 100% asked and answered.
no defined methodology, when you look at a photo,
The methodology is not the serve. Her having the conversation with Alessi is more off-putting, and it might be more off-putting to jurors. Does it change that she has been consistent in what she said? No. But again, experts have to be able to hold their own, even when they are newer experts. And that is part of it. Those conversations have to be had before. You cannot talk to witnesses in the middle of their testimony. But at this point, he's just asking the same question over and over, hoping for a different answer, and he has to move on.
like you do with John O'Keefe's arm, you're just eyeballing it based on your personal
I don't know why the
experience
audio
with dog
changed.
bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
I'm going to allow that.
Isn't that fair to
Now
say,
he's
Dr.
objecting.
Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make, and nurse practitioners and the like, make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment.
That's what
There
she
are
said.
not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would.
Sir.
You can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no...
She's like, I'm using the same standard that we use in medicine. This is how we evaluate things. It's medicine. It is different than fingerprint analysis. Like, just move on.
accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the and the articles that I read, the numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard? And
Can you tell me what the methodology was for the blue paint? Oh, wait. After the experts he's put forward, this is not a serve. I think he made more headway with, oh, now you've been asked to do this, because there will be jurors who are like, oh, you've been coached by the defense attorney in between the overnight. And there are jurors who will not like it at all. I don't like it at all. It is not a good look. Does it change her opinion? No. Has her opinion been consistent? Yes. Has the way she expressed it changed a bit? But again, I know that there's court reasons for that. So am I that fussed about it? No. Based on prior court rulings. Does the jury know that? No. But at this point, just asking her the same question over and over and over again, when he's put forward experts who are like, we're just going to try to see, isn't helpful at all, I don't think. Because again, it undoes everything that he did in the morning. And we've gone from, so you wanted to be here, which is what we see with a lot of experts. It's, okay, well, we're not going to go after your information. We're going to go after you as the expert. That's been pretty consistent in this trial. But trying to go after her methodology of, I have seen and treated a ton of these, and therefore I can tell you exactly what this is, because this is how I would, evaluate it, is not helpful. It's just getting into a boot loop of the same question. And I think he's hoping that she will get flustered with him.
nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine. Dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
Right.
No,
going
that's
back
actually an
after her.
unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at,
Right.
I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and,
Right.
and wounds? What else before I come to my conclusion?
On your ride over here today, were you
Right. He feels like he made
instructed that when
more
I ask
headway
a
with
question,
that.
rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit.
You know, Hank thinks that that question rattled her when he's going back to it because she's not giving him any ground. I don't think she should give him any ground. That is part of being an expert, is not giving any ground. But we've not seen Alessi objecting, because sometimes if you object too much, it looks like you're trying to protect your expert because they can't hold their own. This becomes a big strategy play. But both she and Alessi, and I put this more on Alessi, should know that they can't have that conversation overnight. And before she testifies, he should tell her that. Alessi knows now enough of what Brennan's going to be like, and so does she. She's had that voir dire where Brennan came out of the gate way hotter than he's been here. He's getting there. But they can't do it in between. So he thinks he scored points there asking about it, because the way she was answering changed this morning with, can you let me see that? So I'm not surprised he asked about it, but now we're just, again, stuck in a loop of seeing if he can get a different answer.
Exhibit of Mr. O'Keefe's arm. And I want to ask you some questions about it.
Oh, I'm sure the jury's moved on.
You
I'm
and
sure
I
they
have had many conversations about Mr. O'Keefe's
Yeah.
superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are
the jury probably
superficial
cares
abrasions? Do you
less
agree with
than I do about that.
characterization?
Yes.
He's hoping to get a few
When we
that
last
care
spoke,
about it.
just for background,
That's
to
all.
remind ourselves, we broke these into separate parts so we could discuss them by number, just for a sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2,
Yes.
number 3,
Yes.
4,
Yes.
5.
Which did you call
sorry, this
4?
one,
4,
5.
5, 6, maybe.
Okay, so as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that
Okay.
fair?
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
No, now you've added
I
numbers.
think so.
Okay.
Sheesh.
When you
Okay.
testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing.
Gidget Gale in the chat asked what a lot of you are asking. And again, I don't think they have a limo. I think they probably just have an Uber like SUV with a driver for security purposes to get back and forth to court. But either she said limo, I think she colloquially meant someone driving a car. Pish posh for me. But how does Brennan know what they discussed? He didn't. But she started answering differently than yesterday. He picked up on that and said, did someone tell you to start asking for the transcripts? And so he asked, and then he followed up that line of questioning. I don't think he had a heads up other than that her answering had changed. And it's not inconsistent with how we've seen other witnesses do things in this case. Generally just Commonwealth witnesses, since we're only like 4 witnesses into the defense. So no, I think he was just asking because he suspected something had changed. So that's all. I mean, the defense can't have law enforcement drive you back and forth because they don't have access to law enforcement. So they've got to get some Ubers or whatever.
You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about
might be
this
why
specific
she
abrasion,
changed her mind.
wound number 1? Do you remember
he
you
asked
saying
about
that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
No, I think it's fair when he said, well, it might not be in the report yesterday, that she might have naturally changed her mind on her own, and that might have been the answer. The thing is, it wasn't the answer. It might have been that she clocked that. So.
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
Right,
If
and most
you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the
Again.
beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
I don't think that's
Mr. Brennan,
accurate.
perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails
said that
of
yesterday.
a dog are so similar to the teeth that you can't tell the difference between them
That's
when you're
not what
looking
she
at
said.
a wound?
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
It depends on the wound, Brennan.
Individually, okay, that's a very interesting question. Sometimes it's difficult because
And that's what she said. It depends on the wound. If it is deeper wounds, it's different than if it is superficial wounds. It just depends on the wound. Because again, a dog made these wounds is the point. You're not going to treat a wound different necessarily if it was teeth or claws. Superficial wounds are going to be harder. Deeper wounds are going to be easier.
they can have similar appearing
Similar shape.
wounds. So you have
Right.
to look at the overall pattern in order to make some conclusions.
I think
When
she's
you
been
first started
really
testifying in this
consistent on
case,
that.
you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that the very first time I testified, I mentioned that the overall pattern was important.
Right.
When you first testified, so
She's
today,
been
before we get to your
consistent
testimony,
about
you're
the
saying
fact
this could
that a
be
pattern matters.
either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Remember when you were asked about it and you answered?
You just asked her, didn't you previously say this could be teeth or nails? Yes. So now you're saying you think it's more likely teeth. Yes. But it still could be nails. Yes. But you didn't say it could still be nails last time. She said, no. Last time I said it could be teeth or nails. He has to move on from this. He's not going to, because he's hoping to confuse her or confuse the jury or just piss her off so that the jury disregards what she's saying. But you can tell how important this testimony is, or how important the Commonwealth thinks this testimony is, by this amount of nonsense that we are going through.
You talked about that there was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog.
So you said they're
oftentimes, or
consistent with
most
teeth and
times, are
nails,
horseshoe
yes.
shaped, aren't
So
they?
you changed your mind that they're the same from
They're
teeth and
generally
nails.
conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, you know, at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated
Really, Brennan?
that this could be teeth or claw marks? That was your testimony last year. Teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all we need.
Did you
And
testify
Alessi objected.
at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
Which is fair after yesterday when he said, well, the report says this. And he's like, well, it's not in the report. He made better headway in cross yesterday and earlier today. This is just repasturating the same ground. So,
Any approach?
Yes.
and the points that he made for any relative jurors run the risk of getting completely
When you
lost
first testified on
here.
June 18th, Doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony on page 37.
He's like, look, these things are
Line
different.
7, the questions begin. And you were asked
And she's like, but
what you
the
thought they were.
teeth and
Read
claws
any part you want. but
make a
line
similar
7,
shaped wound.
Starting point.
But look, these things are different. I keep saying they're the same. And Chad, I agree that these are asked and answered.
Yes, I said that, which are
Unless he has to
consistent with
object,
teeth
though.
marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
That's
Okay.
different than how Brennan presented it. So she should bite you, Brennan. I'm teasing the witness should not bite the attorney. However, it would be funny. He pulled his hand away real quick. I was waiting for her to just be like,
That was your first testimony last year, yes?
Emily, you were upset when she gasped earlier. Now you're like, she should bite his hand. I know. The bite is joking. The gasping is a different thing. Look, the experts in this case have gotten very spicy. It would be funny. It wouldn't happen. But he went to go grab the transcript and pulled his hand right back. Because several times now, Brennan has gotten himself into this pickle where he has represented something. Are we surprised? He has represented something. And then on the transcript, she's like, actually, it's this. He's done it over and over and over again with the way that he presents something is just changed from the way it is. So yeah, the witnesses should ask for a transcript when it comes to Brennan asking them questions because it's just shifted off of what it is every single time. Every single time.
Yes.
Yeah, there's always that little bit of a but isn't it this? But isn't it this?
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report?
Yes,
After your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
I don't think
No.
she's going to see it characterized that way. Yeah. He is in the weeds on this. He thinks
Do you
he's
remember-
making headway.
Changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
no,
Are there different types of teeth in a dog?
yes,
Okay. The pointy teeth, the big ones, those are called canines.
correct.
Brennan, have you forgotten your questions?
And the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Who was the
Correct.
attorney that called them incisors? Was it him? I don't remember who kept calling the incisors the incisors. I don't remember.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from
Was it him?
teeth or claw marks
Thank you, Tim.
to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
Oh,
You
I
had never
genuinely
said
forgot.
that the canines
You said so much.
caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified, December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified.
Also, was she talking about canine, a police trained dog with the letter K9? Was she talking about canine, the species of animal? Or was she talking about canine, the tooth? The problem is there is dog canine, there is specific letter K number 9, and then there is tooth canine. There are 3 definitions of the word canine at play in this conversation. So without context of the sentence, it's really difficult to know exactly, are we talking about the canines of the canine or the canines of the K9? Which canines are we talking about?
Several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top-
Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
I'm going to allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so,
I mean, it depends on where the dog's
inevitably,
oriented to the arm,
when you look
doesn't
at
it?
this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree. Yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear.
She
Same
said
thing
the
with number
pattern
three. You've
mattered.
provided opinions on this before.
One scratch isolated is one superficial abrasion isolated isn't the point, though. Like, that's not the point.
If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Correct.
Four, pardon me. Yep. Four, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Right.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could
It's not what she
identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this?
Just notice, in cross, he makes a characterization. She says, I disagree. And he does not say, well, here is the transcript. You said blah, 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 blah. Do you disagree? He just moves on. He doesn't bust out where she said it and confront her with it. He doesn't impeach her with prior testimony. He asks the question, but didn't you previously say each one of those? And she said, no, that's not a proper characterization. And then he moves on. If he could impeach her with it, where is the impeachment? Because we've seen plenty of witnesses be impeached with prior testimony to varying degrees of effectiveness and with varying types of answers. But he's never following through with that last step. And I'm sure she is caught on with this pattern. She says, do you have a transcript? He says, I have it, but do you remember it? And then he moves on. And I saw a question in the chat. Terry said, why is he just allowed to misstate, mischaracterize her testimony? He's allowed to question her about her testimony, and then she's allowed to answer it. Didn't you say you could do A, B, C? No, that's not what I said. She gets to answer. Didn't you say this, that? No, that's not a fair characterization. And then he moves on instead of just answering it. He's now, it seems to me, just trying to wear the witness down, but it also seems that she's on to him and is like, where's the transcript then? And then he moves on. A battle of the wills with the experts will not always yield positive results for the questioner.
Wound, Dr. Russell.
Number two, I believe
Yes, she has recognized his pattern of
that was
questioning
dog
at this
bite
point.
or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty.
She's allowed to say could. Adam, this is a good question too. Isn't it an ethical violation if he's intentionally trying to trip her up by mischaracterizing her prior testimony? He has to have a good faith basis in the question. So if he reads her transcript to say, well, each of these represents dog bites, then how is he characterizing the question? It's really hard to break it down in a more finite way without seeing the transcript. But he can't ask a question he doesn't have a good faith basis in. You would be surprised at how far lawyers will go to say that I've got a good faith basis in that question, especially on cross. You're allowed a lot of leeway on cross-examination, and they are talking about the same subject matter. So it gets hard without seeing the transcript, and he won't show her the transcript.
So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is
Right,
what
the totality.
I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria?
Sumre, that's a completely different timing. They can tell her to ask Brennan for a transcript. They can't do it in the middle of her testimony. The timing is the issue there. The attorneys cannot talk to the witnesses in the middle of their testimony. Before she gets on the stand, they can say, look, you know what Brennan's like on cross. If he's asking you for direct quotations, you have the right to ask to see the transcript to make sure he's quoting you correctly. They can absolutely ask. The timing of it is what the issue is with that, not the thing that it was said.
You can look at and tell us this is or is not a dog bite based on this methodology you have.
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and
Right.
many of these, overall, by the way,
distance apart.
parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either
She just
biting or
answered it.
scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And
At least we
these
can see the
two
pointer.
scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
Right, but
I didn't say that these were caused by canines. And,
dynamic
and
situation.
spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these
Right.
not exact, these two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified
I really wish they
last
would
year
just
on
get back
June
to the
18th,
hoodie.
you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2,
Ma'am,
the top
please
2
don't
linear
ask me to
abrasions,
speak up.
you
It's
believe
too
were
early
either
for us
teeth
all to be
or
yelled at.
claws. You've shared with us now you have improved your study and have
Way
new
too
opinions.
early.
Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently.
Do you
Teresa
have
B,
an opinion whether
congratulations
this
on
is
being
teeth or
productive.
claws or not something totally different than a
That's what I've
dog?
done all morning.
I believe they are teeth or claws caused.
When you testified,
And again, if you're asking, Emily, doesn't he have an expert that's going to talk about this? Yes, he does. It'll be interesting to see what that's like. But everyone who recognizes dog bites, don't they look at the entire arm and say, based on the entirety of the arm, this is what I think? Yes. Yes, they do.
at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
Good.
So, Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay.
It's argumentative.
Did you testify at a more recent hearing
It's
that
argumentative.
teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
Right.
May I
Could
approach?
you just hold 1 second? Could you please turn the fan off?
Because they
Joyce, is it
just-
okay if we turn the fan off so we can hear better?
They just can't hear each other.
Thank you very much, Officer DeLong.
May I approach?
Yes.
I know we've been quite a long way into the exact same question.
From your
over and
December
over.
hearing, page 100, line 5,
For everyone asking, why isn't it asked and answered? There has to be an objection made
you were asked about
by
that
Alessi
second wound
on those grounds.
in December. And I asked whether you changed your opinion from teeth or claws.
And if Alessi looks at the jurors' faces and they're all just like, or they're just like this, he's not going to object. He's going to let Brennan just keep digging a hole. So if Alessi's sitting in court and the jurors are like, for the love, can you move on? He's not going to object. He's going to let Brennan just get that shovel out and keep digging. It's a strategy. So why isn't Alessi objecting when he could? Strategy. Go ahead. Let Brennan look like he's got nothing to ask. So he's just rehashing the same question over and over and over and over. When someone's digging their own hole, let them keep going.
Are just teeth. Weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm
These aren't
not sure on the
objections.
second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this.
Well, my memory was faulty this morning on who was saying incisors. But we are back to the incisor tooth. So there we go. We are back. We are back to the incisor tooth. I wonder if she will call him on it this time. We'll see.
This is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then
Right. She's like, right. That's
Okay.
what I said.
Oh. Oh, yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here, and this mark here. So it appears that this is from upper, and these are from lower. That's what I was referring to.
You know it's repetitive when I have stopped taking notes entirely. Because
So when you
he's
first
just
described
not
these,
making
this
any more
wound
headway.
as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter of factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were
Yes.
asked, what do you think? And you didn't say with not 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Chad, I agree
say,
with
looking at
you.
wound 2 alone,
For those of you
You cannot
listening in the
say-
background, Chad is saying, okay, so teeth or claws, still not taillight. Right. But he is going to say, well, she can't say where they came from, so you have to go with our expert. I don't know how that's going to fly, because a lot of you are like, I really don't care if they're teeth or claws. I would like to know if they are dog or tail light, not teeth or claws. He's trying to say, look, there's no methodology, so she can't say this. I think that's a difficult argument to make in light of her experience. So what he's going to try to argue with this witness is that she inserted herself into this case. She wanted to be in this case. She reached out to attorneys to try to talk to the defense team to be in this case. I find her answer, I wanted to answer the question, and I saw a question that I could answer, and I wanted to say, hey, the answer to this question is this. I don't think she expected that she would end up testifying in it. Maybe she should have, but I don't think she expected that to go that way. Or at least I believe her when she said, I didn't want to end up here. I just wanted to answer questions. But he's going to say, see, she parachuted into this case. She's interested in dog bites, so everything to her looks like a dog bite, and there's no methodology to determine whether these are dog bites. And then he's going to bring in his expert to say nobody could determine that these are dog bites. It's going to be difficult based on her peer-reviewed articles and her experience. But after yesterday, if there are jurors who are like, is the defense trying to pull something over on us? And there are jurors that go into it skeptically while looking at defense attorneys. Are these attorneys trying to pull something over on us? Did they threaten Dever with perjury? Are they telling this witness what to say? Brennan might score a few points with jurors who are going to be in the jury room pushing back because he's fighting for jurors to be on his side during deliberation. That is what we are seeing going on here. Who's going to be on his side during deliberation? Which jurors are going to go into the jury room and say, right, but if we don't know their teeth or claws, and other jurors are going to say, okay, but still not a taillight. I just wish they would get back to, and I think it's more instructive, the hoodie. Look at the hoodie. Does that hoodie to you look like it was ripped by something sharp, or does it look like it was punctured by something that has a bit more thickness to it? Does it look like a thin shard that cut it, or does it look like something rounder? I wish we would get back to that. I hope that Alessi does. We know why Brennan's not going to. But Brennan's like, so he's just teeth or claws, teeth or claws, teeth or claws. Okay.
This was
Can we
caused
move
by
on?
a dog.
In and of itself, no.
Yeah, I find the hoodie incredibly instructive. I mean, and I don't know but I have more experience
tooth do you
with
think
ripped
caused this
clothing
wound?
than I do with dog bites.
I don't know.
So that's what's helpful to me. People who have experience with
Do you think
dogs
this in any way could be caused by dog teeth if you're claiming
generally
that this is dog
see
teeth?
this the same way.
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two were caused by dog teeth?
Yes, could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Ma'am, the Commonwealth has said if it's just a glancing strike, it's a cure-all.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm
Squishy
not
people do.
claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm,
This is actually a helpful area of cross-examination. He's been asking questions for 84 years on the same ground and is actually now treading into a new area that I think is a more helpful area of cross for him.
did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So
Right.
are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's
Dude.
arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
What?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on
It's
Mr.
like, let me
O'Keefe's
explain
arm.
how jaws
Are
work.
you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes, and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes.
I think that area is
Your
going to
claim
have more
is that a
headway for
dog
him than any of the
penetrated
others.
the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell
That's
us to a
argumentative.
reasonable degree of medical certainty whether or not this was caused by a tooth.
Objection, Your Honor.
We're going to strike the first part. Why don't you ask the
Yeah, because
Can you tell us to a reasonable degree of medical
striking it.
certainty whether this superficial abrasion, put that back up please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr.
The
O'Keefe's arm
computer's
to a
over
reasonable degree
it.
of medical certainty where the lower jaw impacted Mr. O'Keefe to
The
leave
computer's
even
just like,
scratch?
nah.
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so
That
I want to
is
be
accurate.
Well, you have the
Specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank
No
you.
You have the opinion
commentaries
today
needed.
that this was that those were either teeth or claws.
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you
Also
give us
too
an
much
opinion
commentary.
regarding the cause of those marks?
Objection, Your Honor.
Yep.
So I'll strike the comment.
Yep.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Notice that he didn't pull out the transcript. The jury 7 weeks in now knows if there's a serve to happen in the transcript, how that is going to go. They're going to walk up with the transcript and be like, and then you said. Playing word games with her is just going to lose everybody in the weeds. And he moved on, and then he came
Did you ever
right
change your
back to
mind?
this line of questioning, like a dog with the bone. He just, she has said it, she has said it, she has said it. Like, what is happening?
About the source of these abrasions.
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
Right. I really hope the redirect from Alessi is just, do you have an opinion to a medical degree of reasonable certainty that the injury from the arm came from a dog? Yes. Do you have an opinion as to whether or not those injuries were caused by a car? Yes. What is that opinion? This. Okay, great. That's the point.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed,
Things move.
you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses.
It bunches. It
you could
moves.
have two prongs, for instance, of a pitchfork, for instance, just as an example, impact
Not a terrible
the
example.
skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
And
This
if
is not a slight difference, Dr. Russell, is it?
everything in this equation can move except the distance between the teeth. If we are talking about a dog, the dog can be moving, the human can be moving, the skin can be moving, the skin can, there are a lot of dynamic properties to that. So no, the spacing of the teeth's not going to change. Everything else in the equation is going to change. What he's arguing is because the spacing is different, they can't come from the same teeth. And that's just not going to be helpful.
Again,
Objection, Your Honor.
So there was a question of that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine
like, "Sir."
teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you
Oh,
note
look.
that in the report? Did you
No, I
actually
did
measure
not.
them? Take
She's a doctor. And she looks at things and goes, yes, I can approximate the wounds, like doing an assessment. Weird.
Excuse me. Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that
You
process
can't do
during
that
your
because there's no ruler on the
methodology?
photo.
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process
You
of measuring?
can't measure the distance on a flat photo of an arm that is bent and you don't know which point is closest.
Them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, a report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, Doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So if
methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes, I don't know how to answer that.
Well, Try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However,
I don't know if he's going to regret getting into the area of a collision, but I'm interested to see it.
I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with, and that forms a basis for me.
Do you really think?
I'm sorry, can you
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of
He is now downshifting the argumentation.
Victims of motor vehicle accidents. I've looked at their wounds. I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis, to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident,
Right. Mm-hmm.
it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case,
Yes. Yes.
I didn't have a lot of information. That's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collision?
Ma'am, do you have any certificates about vehicle collisions with your 187 years of experience as a medical doctor in one of the busiest ERs in the country? Do you have a certificate about car accidents? No, you just try to save people's lives after they've been in them. Okay, my bad. My bad. This is a wild choice for Cross to try to go toe to toe with this doctor over whether or not she has a certificate in accident reconstruction. He should have stopped while he was ahead earlier today. So you can't say individually, these are this. You can't say if these are teeth. You talk to the defense, you are changing your testimony, which I think she responded to. You can't say if these are teeth or claws. You can't say this, you can't say that, and just leave it. But now that we're going to get into, but what about an accident? I think on cross, he has actually made it easier for Alessi to come in and say, you're saying that you look at this arm and it is your opinion. Well, this is all in the style of cross. It's your opinion that these come from a dog. Yes, yes. Okay. Well, in all these things you've seen with vehicles, are you telling us that this is not from a vehicle? It's made it easier for Brennan to ask those questions because he's asking those questions. Much easier. And Alessi can ask those questions all day long after Brennan is now asking them. He was very cautious about how he asked that on direct. And Brennan has just kind of kicked open the wall on that for a lot more conversation, which I think is an error.
Actually, I did receive a certificate in hit and run accident investigation
Oh, my bad.
from the Massachusetts Criminal Justice Training Council when I was a police officer.
My bad. Bad. Well, actually, he should have seen that coming because it's probably something that is pretty common for the academy. My bad. She's like, well, actually, yeah, I do. Right.
Yes.
Let me back that up.
Yes.
Right.
I didn't have a lot of information. That's correct.
Okay.
Right.
And so
right.
in order to rule out a collision causing these wounds,
Right.
let me ask you, are you an accident
I backed up.
reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training
Right.
Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of
Accident- Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a
Are you ACTAR qualified? No, but I completed multiple fellowships. Y'all, this is such a wild choice to fight with this expert over qualifications after some of the fights over qualifications that we've seen in this case? It's just a really strange choice, because if you are, I am not judging, I am genuinely curious. Does anyone think that doctors in ERs don't know what people look like after they've been in a car accident? Like, is there really some genuine confusion that she's not seen injuries from a car accident, or that coroners don't know what injuries look like from a car accident? She's done over 500 autopsies. Is there any confusion that because she doesn't do accident reconstruction, she doesn't know what injuries look like from a car accident?
car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
Right.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety.
Right. Injuries are her area of expertise, not trying to recreate how an accident happened. I also still have questions from your accident reconstructionist who just said it happened.
Variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have you
Yes.
studied that before you
Studied.
gave this opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly.
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January
Slowly or
29,
fastly?
2022 at about 12:32 a.m., right
Sounds
around
like
the
me when I'm
time
tired.
that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several
That's not
inches of
accurate.
snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground,
She
the
said
cold, hard
several.
ground. Did you see anything that said that?
Yes, I saw an area of grass
Have you ever
in the
looked
picture.
At, have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the pants?
don't know if I looked at the pants. To
When you
tell
say you
the
didn't
truth.
see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
let's, we'll come to sidebar, Mr. President.
Well, that was argumentative. We're gonna zoom past this sidebar, and again, he has areas of cross that are productive for what he wants to argue, and then it all gets completely lost in just wild questioning that
Suggesting that
isn't going to help him move the needle forward at all. So all of it just gets muddled together in this. So outside your area of expertise, you say to the ER doctor, it's absolutely wild. But I think it shows to, well, anyone who's watching, including the jury, how important and concerned about this testimony he is. Because in other cross-examinations, he's kept it pretty short. This, he has definitely not kept short. I think it shows that he is concerned greatly about this testimony based on how much he is, I don't know, repeating the questions.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have
Shocking.
any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
I'm sure she had the
Yes,
whole
but
autopsy.
no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have
I know,
you seen
Chad.
in your
I don't think it's
history
helpful either. It's not the job. The reason it's not sitting well with you is because the job of the prosecution is to clearly show that with all of the possibilities, this one thing happened, and that all of these other possibilities aren't actually possibilities. They're not reasonable possibilities, just the one thing. And he's getting into, is this possible? Is this possible? Is this possible? Is this possible? Which is why it feels disjointed, because it's supposed to be this one thing happened, and the cross should be focused on this one thing happened. And you're saying something different happened, but did you consider these things that all point to the one thing that happened? And that's not how his cross is going. His cross is going very much like a defense cross, which is bring up, mention it all the possibilities. Could be this, could be this, could be this, could be this. He's throwing in all the possibilities, but he's not narrowing it down to the thing he said happened.
multiple
That's the disconnect.
victims of a car collision and where
Many.
they were
Sorry.
hit by the same car?
It seems that he indirectly said, but could it be bushes? That's how I
Probably,
heard it
but
as
I
well.
can't recall a specific case.
Would you agree with me if a car ran into a group of people
Why are we talking about a group of people?
and caused a number of injuries? Those injuries to different people could vary wildly from one to another.
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
I mean,
Could you
are we
repeat
talking
that?
about external or
Are there
internal?
instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries. Correct.
So a car collision can cause...
Brennan, isn't your argument that this vehicle collision caused a fatal head wound? Is that not your theory here, that the vehicle collision caused a fatal head wound? So are you saying that this fatal head wound could be caused without a car involved at all? Because two of your experts said this collision, the injury to the head does not need any more inertia or force than a fall backward, whether or not initiated by a car. So are you getting to, we don't even need a car in this equation? Because I thought you charged this case based on a car being part of the equation.
Wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a car, a vehicle's involved, have you ever been involved in treating patients that receive injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
That's a
When
good
you
line
are
of questioning.
considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or
should've just
impact as the source of Mr. O'Keefe's
done this and
abrasions,
stopped with all the teeth and
about
claws?
what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you con-
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
I thought she wasn't a reconstructionist. Why are you now asking her about debris fields? Is it because she knows something about accidents? Because you're asking her questions about accidents.
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Well, there's your answer.
If you ever, as a police officer,
If you want to ask her about confirmation bias, then ask her about that. So you couldn't imagine any other possibility because, everything's a dog bite. Fine, then ask her that. I don't know why you're getting into debris fields.
looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian. Yes,
Okay,
not
right.
as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that
I don't know that that's gonna change her
that
mind.
there was one shoe off. Correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware. I have been aware of that. Yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please?
This area of cross would be much more
In your
helpful to
study to give
him
an ultimate opinion,
if
where you suggest
we weren't so
that
far
a
in the
car
weeds.
collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
For the scratches, no.
It could be important. However,
For
it
his
could be.
arm?
If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please.
Okay. But
When you were reaching
weren't you
your
asked to just
conclusions,
evaluate the arm?
you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
Not
76A,
specifically
please.
that photo.
Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
This is a much more helpful avenue of cross for him to be able to argue what was not considered.
You can take that down, please.
But
Would
again,
there be
it
any
gets
significance
lost
in your study,
in everything else.
in the foundation of your opinion, that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken and missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
it was important to know. I still don't understand the question. I'm having a trouble
Okay.
understanding the
It's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
Yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision
Okay.
between Mr. O'Keefe and Miss Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Why would she need to?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked. Yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I didn't. I don't know that I ever saw this picture.
Seeing this picture, do you see that
What's
the
it
right
matter?
rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
She already knew that information.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
It's a fair
I'm going
question.
to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Boy.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the
Depending on the statement, veracity
the veracity of the
of the
witness.
statement. Right.
Have
It
you
really
listened to
depends.
the statements of the defendant herself in this case regarding potential impact?
No, what do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about, did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis?
Would any of those
whether or
change
not
her
there was
opinion?
a impact of collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
Would any of those change her opinion?
I did see some
About
statements,
the
but that was
car?
after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way, change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Oh boy.
Because she had, the defendant had undergone a very stressful event.
Oh boy. Oh boy. Brennan, warning, warning. You just opened a box that you didn't want to open. Did you hear how her response started to change? Absolutely not, and I'll tell you why. Let me explain why I don't think any of those statements matter to what I evaluated based on the arm. Danger, Brennan, danger, danger. You have tread into an area that I think is going to blow up in your face. Did you see her demeanor change? Her whole demeanor changed. She's like, let me tell you what. Oh boy, Brennan, I think you stepped in it. I'm real interested to see where this goes, but I think Brennan just stepped right into it by asking one question too many. Oh dear.
Mention it all. Mention it all.
I'm going to back this up to Brennan's question and let her answer, but you watch the shift in her demeanor. She is about to just run through the door that he opened, I suspect. Did you see those statements? And I think this is the basis. You let me know in the chat if you disagree. I think he is leaning so heavily into Karen Reed's statements to be the cure-all of this case. Did you hear the defendant make all these statements to the media? And did that change your mind? And she's like, absolutely not. Who do you think deals with people under stress more? Deals with people after traumatic events more? Brennan or the ER doctor? Who do you think deals with people who are intoxicated more? People who have seen loved ones die more? Who's done that more? This witness or this defense attorney? I'm sorry, prosecutor. Danger, Brennan. You have opened up a door. Well, let's see how that goes for him. Bold strategy.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way, change the analysis of your opinion?
We're back to absolutely not.
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 20/20 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year later, year and a half later?
A grief reaction can last years. It's usually it's very brief, but it can last years.
Now, when you looked at the clothes in this case,
He actually took that in stride pretty well as the attorney. But she said that can last for years. It's normally immediately after, but that can last for years. I'm surprised at how well he took that in stride, because there is no way that's the answer he anticipated. And he just gave a massive, beautifully wrapped gift to the defense of talking about grief responses. And it is an area that they would not have gotten into but for Brennan's questions. If the defense had elicited this, Brennan would have absolutely lost his entire mind. But he's the one who got into it. And so here we are. And we've already seen testimony somewhat like this from Carrie Roberts. She said repeatedly, I did this, I don't know why. I did this, I don't know what I was thinking. I was just doing things, I don't know what I was doing. I was just trying to do something. And so we've heard Carrie Roberts also saying, I can't explain to you what I was doing. I was doing things I don't understand why. And now you have this doctor explaining away every single video clip that the prosecution has shown in one fell swoop. We'll see how the defense uses it in closing, but she is talking about a grief reaction, saying, yes, it's immediate, but it can also last. And Brennan's going to discount it and be like, well, you can't have a grief reaction when you're on 20/20 or whatever. But the jurors that were looking for more context, if any, on those statements now have that context. So if you have jurors in the back saying, but what about Karen's words? You now have other jurors saying exactly what Dr. Russell just said. I imagine everybody's little pens are going like this. Oh boy, Brennan, you flew too close to the sun on that one, didn't you?
Mr. O'Keefe's clothes. You are aware that those clothes were swabbed
He moved right on.
for DNA traces, aren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have exhibit 147B, please?
He moved on well, but yeah, really interesting.
On the
Really
right
interesting.
arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
That those holes were swabbed for traces of dog DNA.
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
Well, the prosecution has not called anyone about what is on the shirt. However, they did call the person who swabbed it. The victim's injuries were not swabbed. The clothing was swabbed. And we heard about the clothing being swabbed, but we did not see anyone who tested it, and there are no results in evidence at all. All right, they're going to approach. They brought in that it was swabbed, but they did not. I saw a lot of you asking, I mean, there's over 50,000 of you, so rapidly. They brought in the swabs. They did not bring in the results. at all. So let's zoom past this sidebar.
Mr. Alessi, I'll hear you.
Did they let the jury out? Not who let the dogs out, Emily.
Please.
They let the jury out, it seems.
Give you the morning recess. That's about a half an hour.
They're giving the jury the morning recess.
All rise for the court, please. Those in your notebooks, follow me.
Okay. They let the jury out.
The court, please be seated.
We're doing a voir dire. Miguelina, will you let the app know that that the jury's been excused for the morning and we're doing a voir dire?
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Oh boy.
Mr. Brennan, can you remove? Oh, okay, it's being removed.
Thank you, Your Honor.
There's a lot happening in this courtroom right now between the attorneys.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice.
A ton of shit has happened in this trial. And we have never seen the defense ask for a mistrial. And I have regularly said the defense does not want a mistrial because then it happens again. A mistrial with prejudice is a mistrial that cannot be retried. It is, we are granted a mistrial and this case is done. I see all of you asking for code red. We don't know what the fuckery is yet. So I'm waiting. Alessi is at code red. Alessi is pissed. The hoodie was swabbed. We heard evidence that the hoodie was swabbed. The prosecution did not put in any evidence of that swab being tested. They only said it was swabbed. And now the question that Alessi is responding to of Dr. Russell was, did you consider or do you know that the hoodie was swabbed for dog DNA? Oh boy, is Alessi mad. I'm going to let him make his request again and then just let him go because oh boy, is he mad.
The concept of DNA in this case, he has introduced it and brought it in for the very first time in front of the jury. I'm trying to look at your questions
as well.
He has done so intentionally. He intentionally brought up DNA. Based upon that
was an intentional question,
mention,
100%.
the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy,
Alessi's got all the only
remedy, is a mistrial with prejudice.
Okay, thank you. Mr. Brennan.
The Commonwealth has presented the scientific witnesses that swabbed the gray hoodie. They did not offer any evidence of testing of that gray hoodie at all. So to make the insinuation, did you consider dog DNA? There's no evidence that it was ever tested before the jury. Oh boy. Well, now we know what they were arguing about at sidebar.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury.
The jury doesn't have that information.
Be clear, the defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear, the defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it, she discounted it, she created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January...
Did she testify about it on direct? Because I didn't hear her testify about it on direct.
January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It's
not before the
powerful
jury.
evidence that the Commonwealth has to undermine this idea that the linear, superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use.
It's
They do
not
not
an
get to
evidence.
pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense about...
How can it go to the heart of her opinion if it wasn't stated as a factor of her opinion in direct, though? I don't understand that part.
The heart of her opinion, she shouldn't give it. She shouldn't have an opinion because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence because it shows her inherent
no DNA
bias
evidence
in all of her opinions.
before the jury.
Where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Johnson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I have 30 seconds.
Sure.
The court's giving them notice that the court has given them more time to argue this. The court did not hurry anyone along. The court did not tell anyone to hurry up. The court let the jury out and is allowing them to argue. Oh boy. Look, we have pondered whether the narrowing of the evidence would come back to bite the prosecution. Are we there? Oh boy.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the
It's not in
motivation is
evidence.
for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 12th, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alessi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alessi. Wholly.
All right,
But-
thank you. We'll give everybody.
Can we just but it's not in evidence in this case before the jury. Okay.
A half an hour. So
All right.
Well, the court is giving everyone a half an hour and gave the jury a half an hour. The court is going to resume. I think, though, it might be a good time to take a very brief bathroom break. Let's talk about what just happened. We're still before lunch on day 26. Dr. Russell is still on the stand. There was an objection during cross-examination after Hank Brennan asked Dr. Russell if she had considered whether or not there was DNA on the hoodie, and I am paraphrasing because we have just been through a ton of argument about this issue. There was a swift objection from Alessi, then a sidebar, then the jury was excused, then the attorneys argued in open court on the record, and then the court continued with a half-hour break. When the attorneys argued on the record, Attorney Alessi asked for a mistrial with prejudice based on the Commonwealth's question to Dr. Russell about whether she relied on or whether she knew and considered that John O'Keefe's hoodie had been swabbed for DNA. And again, that is me paraphrasing the question because we are at the end of a lot of argument. Alessi argued that this should be a mistrial with prejudice because the defense has not asked about it, the defense has not elicited it, and the Commonwealth has not presented it in evidence. Attorney Alessi argued in that Brennan has to have a good faith basis on the questions, that the questions are based on admissible evidence. Brennan argued that this can come up in rebuttal. However, it's not in evidence before this jury. The prosecution elicited testimony that the entire arm of the hoodie was swabbed, and no testimony about whether that was tested. There was little bits of evidence that those swabs had been sent out and that someone had seen that in a report. There were a few mentions of it, that someone saw in a report that swabs might have been sent out, and there might have been a report from someone at UC Davis. It was never followed up on. And the only reason I think I even picked up on that is because we knew about it from the first trial. So now we have Alessi saying there needs to be a mistrial with prejudice based on the prosecution insinuating that there's DNA or lack of DNA on the swab from the hoodie. That's not in evidence. The prosecution did not bring in the witness who tested those swabs. So there's been no conversation about the swabs. There's been no conversation about what might be potential issues with the swabs, why they might not show DNA, how long it was waited till they were swabbed, the methodology of the swabbing, how the entire sleeve was on one swab, all of the things that you would ask the person who tested it, those were not asked because that person never testified. When the defense is asking for a mistrial with prejudice, what they are asking is that the court declare a mistrial and not allow the case to go forward this time or ever. Dismiss, done. Not a mistrial, we start over and do this again. A mistrial with prejudice, like in the Baldwin case. That's what Alessi is asking for. Brennan argued the defense can bang their fist and yell as loud as they want, but we can ask these questions if Dr. Russell considered it. And we know Dr. Russell considered it because Dr. Russell has testified in prior proceedings that she considered it. So we can ask Dr. Russell, what did you consider? Did you consider whether or not there was dog DNA on the shirt? And Dr. Russell can answer, I didn't think about that, or I did think about that, or I discounted it entirely. So the argument from the Commonwealth is, no, she read the reports. She's allowed to consider anything in those reports, and we can ask her if she considered it or not. But the results are not in evidence. So with the results not being in evidence, that is why the defense is so frustrated with this. And the Commonwealth said the defense has always known that we were going to bring this up with our rebuttal witnesses. But if you're going to bring this up with your rebuttal witnesses, it needs to be in evidence. How do you get around it being in evidence if you're going to bring it up? Are you going to bring that in rebuttal? I imagine not. But that is what popped off before they took a long break. I have had all of the water today. I'm going to take literally 3 minutes to run to the restroom before we resume because court has gotten very spicy. But I need just It is rare before the lunch break that I need 2 minutes to use the restroom, but today is the day because, oh my goodness, today. It is a retrial. It should not be that spicy. I don't know if the court is going to rule on this. If you have watched ahead and you know, please don't share it in the chat. We're going to watch together. But it's going to be real interesting to see how this goes and what the court allows or doesn't allow. It's not in evidence. But are there times that experts rely on things in other reports that have not been put in evidence? Yes, there are times that that happens. It's going to be really interesting to see when and what the court rules on this and how, because if this expert relied on it, you generally are allowed to consider it, but this expert did not say in her direct that she relied on this as part of the things she said she relied on. She walked through, I relied on this. And she's allowed to rely on things that may or may not have been entirely in evidence. But she did not say she relied on this. And with it not being in evidence, I don't think they can ask if she considered it. But I would need to look more fulsomely at the rules in Massachusetts. But I don't think we can unring that bell, which is part of the problem, because now the jury has heard, well, what about dog DNA? Oh boy, oh boy, oh boy. We are just in the weeds with all of it. So I'm real interested to see. But if the court considers anything, I don't see the court considering a mistrial with prejudice. I don't see the court considering that at all. And it's actually kind of surprising to me that the defense has asked for a mistrial with prejudice after we've seen them ask for other remedies so much in this case. I don't see the court granting a mistrial with prejudice. And if the court said, I am inclined to grant a mistrial, I suspect the defense would say, no, we need a different remedy, a jury instruction or something. We need a different remedy. Because the defense, I imagine, does not want a mistrial where they just do the trial again. With prejudice means the entire case gets dismissed, and I don't see the court going that direction at this point on this question. But we will see. I'm going to run to the bathroom for 2 minutes. Law nerds, don't forget to get the app. I probably won't ping the app when I'm back because I'm just going to go to the bathroom for like 2 minutes. We're going to take the shortest of short breaks, and I will be right back. So thank you, law nerds. Oh boy, oh boy, oh boy. What a wild day in court, because apparently nothing in this retrial is going to just be a retrial at all. All right, I'll see you in just a minute. on break, but don't forget to download the Lawnard app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnard app has all of your live court notifications to keep you in the loop. LawnardApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. All right, everybody, thank you. It is rare that we need a break mid court day, but A, I am trying to hydrate. B, today has been wild and my brain is trying to process all of the things. And C, what is even happening in court today? We're going to get back to it after they took a pretty extended break this morning after multiple sidebars and then argument outside the presence of the jury. They are going to be back. Well, it looks like with the witness on the stand. So let's see what the court has to say as they are coming back, because this morning has been quite a lot, just quite a lot. It's interesting to me that this was the defense request. We have seen a lot of requests from the defense. We have not seen them request a mistrial yet. It's not uncommon that it happens during the course of a trial, but it has not happened. And I've noted a couple times that it has not happened. And here we are. So let's see where we're at.
Please be seated for the session.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation.
Right, there's
So
no
if you
foundation.
can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh,
You're asking for a voir dire of your own
but not right now. They're
witness?
on their way. All right. Do you have an...
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to being done outside the jury. That it should be done like I.
No, he's asking about, let me back that up. He's asking about asking Dr. Russell about Walsh's opinion.
And has
Okay.
been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
I'm going to back that up just a little bit further. He is asking to be able to ask Dr. Russell about Dr. Walsh's opinion?
Issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
Okay.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
No.
Oh, yes, but not right now. They're on their way. All right. Do you have an...
I'll work around it.
Okay.
I mean, that's the same foundation about asking
Being done outside the jury. That it
about
should
your
be
proposal
done like
report.
I had to do with several witnesses in front of the jury.
Okay. If that's what the defense wants. Are you sure, Mr. Alessi?
Oh, I'm sorry, let me confirm with my.
Walsh is the rebuttal witness for the prosecution.
We are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
So they are going to do a voir dire on that.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Are the lunches here?
So they're asking to do a voir dire about whether or not Dr. Russell relied
Are
on
they
Dr.
still
Walsh.
Over there?
They're asking about when the jury is coming in. Brennan said he's going to be done quickly with his cross. So
If they're downstairs.
Brennan is saying he's going to be done quickly with his cross. So he wants to be able to do the voir dire about reliance outside the presence of the jury now because he's almost done with his cross. The judge is saying you can do it later. The jury is coming up and is now trying to figure out when they are going to ask that voir dire because Brennan's saying he's almost done with cross. We will talk about the ruling in a
On their
minute.
way up, I don't want to stop them.
I can do it in 2 questions.
Yeah, please.
Oh,
He's saying he can do
Excuse
it right
me?
now.
This way.
great. Okay, they're going to stay.
Your Honor, if it might help, obviously with involving subject matter because based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's scheduling.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now. Okay?
All right. They are going to do a quick voir dire of Dr. Russell to talk about what foundation there is for whether or not Dr. Russell considered the Commonwealth's experts report. With the court's ruling, so the court came back quickly and denied the motion for mistrial and said that she would allow Alessi to continue asking about the consideration of the presence of dog DNA or not the presence of dog DNA. The question of whether or not to grant a mistrial is squarely within the discretion of the court. I don't think there's foundation for whether Dr. Russell relied on this or not, but the answer is not in evidence because they didn't put the DNA in evidence. So I'm not surprised about the mistrial ruling. I am surprised that she's allowing him to continue down that line of questioning that there is no foundation in evidence for it. But again, that is within the purview and discretion of the court. Cutting off that line of questioning, I think, is the easiest way to handle it. But that's not what's happening. So we're going to see the voir dire and ask if there was any question about it. A lot of you are asking, do I agree with the ruling? She wasn't going to grant a mistrial with prejudice. So yes, I agree that she didn't grant a mistrial with prejudice. She wasn't going to grant a mistrial with prejudice. If she was inclined to grant a mistrial over that question, the defense would have asked for a different remedy. So do I think that she was going to ever grant it with prejudice? No, not on that. I am surprised she's allowing the questioning regarding something that's not in evidence to continue because it's not in evidence. So I am surprised that she didn't just strike the question off the record and not allow him to continue down that line of questioning. That's what I'm surprised about. The not granting a mistrial with prejudice is a very high hurdle. I don't think that question crossed the hurdle. I think stopping the testimony, striking the question, and not allowing further questioning about it is where I thought that would go. I am surprised that they are seeming to consider allowing further conversation about whether or not there is dog DNA when there's no evidence in this trial about that either way. That I am surprised about, and that I do not agree with, because there's no foundation for it. And the jury has no evidence of it. But they're going to ask about the foundation, about what she considered and what foundation she has. for considering another expert report. For any of you asking, why is that different than whether Trooper Paul's report was relied on? Well, we're getting the questions about it now. The court said she doesn't think there's foundation for it yet, so we're getting there now to see if this expert relied on the other report to ask about it, which that is a proper line of questioning. Did you review this expert report? Did you rely on it? But without having the DNA and evidence, I don't see how you can continue to question the expert who said, I didn't rely on that. Especially when the question is, well, did you know this was swabbed for dog DNA? It puts out there something in front of the jury that's not in evidence, that's not for them to consider. All right. I'm interested to see where this voir dire goes, though, because now we're doing a voir dire of Dr. Russell again. So let us see what happens.
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Or,
Is Walsh someone else? I thought Walsh
Dr. Russell,
was...
Did you ever review or receive that document?
Who is Walsh then? I am now confused.
From the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard. I disagree with his assessment.
Thank you.
Chad, I agree that Walsh is a rebuttal witness. I thought Walsh was a different rebuttal witness. The amount of rebuttal witnesses is confusing. So did she consider or not Dr. Welch's Deputy Medical Examiner's report? Whew.
I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had
With Dr. Paul,
possible
with Trooper Paul.
witnesses disregarded it, and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
what do you say about that, Mr. Brennan? How is this any different?
It's not different at all.
I'm talking to Mr. Brennan. How is this?
It's not different at all. It's not different at all. Did you hear what Alessi said? Under the standards set in this court, it's the exact same situation. No, I didn't consider this. I saw it. I didn't consider this. Exact same as Trooper Paul's report. I saw it. I didn't consider it.
With this witness's analysis.
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Alessi?
What?
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Paul, Dr. Scordivello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Scordivello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Paul.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan, so you can mark the...
Alessi's like, you want to know how it's the same? Let me tell you. This. And the court's like, yeah, I'm not letting it in. I'm not letting it in. That's right. That's exactly right. Brennan, you can't have it both ways. You objected. Your expert relied on Trooper Paul's information way more than this expert relied or didn't rely on anything. It got kept out with regard to Trooper Paul. It gets kept out with regard to this expert. That's consistent. So that line of questioning got shut down because that's what
Report if you want.
it's
But
consistent.
for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark.
Okay. All right. Thank you, Hunter.
I think it's funny because she's like, well, Alessi's going to keep going with examples here. I'm just not letting it in. All right. They are bringing the jury back in. That line of questioning has been kept out, but I suspect we're going to hear more about dog DNA, which means Alessi is going to likely have to address that after lunch. If they get to it after lunch. I thought we were just zooming till the jury came back, but then Alessi stood up to talk, so we backed up.
Objection. Where are we? Is it in evidence now?
It's not yet. It will.
I don't even know where we are.
The DNA. It's not.
It's
right?
not in evidence.
Okay. Yes, it's open. I denied the motion and allowed the line of inquiry.
But it's not in evidence. Like, so the line of inquiry about the DNA is being allowed in. The line of inquiry about the rebuttal witness's report is not being allowed in. But it's not in evidence. Okay. They are bringing the jury back in. And now we are getting back to the cross-examination. Well, I think I meant to unpin that message, not remove it. I think the redirect of this witness just got substantially longer. And how does the defense address it? Well, the defense is going to address it. This is how I think the defense is going to address it. So you didn't consider the DNA testing in this case. Why? Well, I couldn't rely on the chain of custody because this. I couldn't rely on the testing because it was all one swab and this. I couldn't rely on the DNA results because this. And the DNA results didn't show dog DNA, but they showed pig DNA, which is not here in evidence yet. They didn't show dog DNA, but they did show pig DNA, and there's things that dogs can eat that have pig in them. So there's always the consideration that perhaps it is from a dog's mouth that had been eating things with DNA in it. So I imagine the way the defense is going to address this is, so tell me all the reasons why this was fucked up, why you can't rely on it. So we're going to be here on redirect for a year and a day because the defense is going to go through all of that explanation. If Brennan's going to ask, well, was no dog DNA being found a consideration for you? Brennan's already stepped in it with this witness. I imagine with this witness, it's going to be like, let me tell you all the ways that I didn't consider it because it's not reliable. So we'll see. I'm surprised. As yours said, Alessi said 30 minutes. Yeah, before the court's ruling, he did. But the court is allowing this line of questioning. So that's going to change. That's going to change a lot. All right.
Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell,
She's
we
like,
were talking about your differential diagnosis and your opinion that Mr. O'Keefe abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a
She
collision.
didn't review
You
that as
remember
part of
photograph
her-
you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen-
on the ground.
That's not what she said. She did not review that as part of her evaluation in this case. She went through Dr. Welcher's report with the case study to highlight the differences on direct, but it wasn't the basis of her report.
His face was redacted, and there was
Oh,
some
that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to
That
deduce
calls for
or
speculation.
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as
He's gone a
opposed to being
totally
directly run
different
over?
avenue.
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed
I want to know
the
what you
height
think
and the
of that.
location when it touched Alexis? Did you see that?
I'm going to allow that.
I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows.
He's gone a completely different direction with look at all the things you didn't consider. Look at all the different things that you didn't consider. Okay.
The operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
Oh,
It can
boy.
actually, a dog can froth, is what they call it.
Going back around
Excessive
there.
Saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to
Interesting
that previous
approach.
question, however, the swabbing was done many weeks after the death. And,
Right, he's going to step into it with
and
her.
There were images of clothing on the emergency room floor. So, yes, I am aware that there were some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your
Oh,
medical
that's argument.
objective opinion?
Yeah, that's argument.
So you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA,
Leading.
That's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the
I
information,
don't like it at all. I really don't. To be allowed to go into a line of questioning when something hasn't been admitted into evidence to sidestep the issues with calling that witness, I do not like that it is allowed at all. I do not like that it is allowed at all. Oh, and you all are reminding me, of course it's leading, Emily, it's cross. Yes, you're right. We're in the defense case and my brain is buffering because I do not like this line of questioning at all. Are they going to get to ask about it in redirect? Yes. But I don't think it's a proper line of questioning at all. To sidestep a witness, to just be like, you knew that, right?
after you claimed there is a dog with John O'Keefe, when you saw the information that they were swabs,
I think it will
none of
backfire.
those
I just
holes
don't
in
like
the
that they're even getting
results
there.
were no dog DNA. Did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence.
Hey, Brennan, if that evidence was so significant, why isn't it in your case in chief? If it's such significant evidence, where is it then?
In the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
We're talking about
I
foundation?
explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons. Didn't you?
Well, it's not in evidence, so isn't it all speculative
So
at this
The
point?
objection sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go
Consider
through a
all
process
possibilities?
to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know
Right.
about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use.
Wait.
Possibilities why
Wait a second.
there were errors with the DNA.
I think I learned from some engineering experts that if you get new information, then you consider the new information. How is it different?
Okay. Yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm
Oh,
sorry.
sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly? You know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after
Or of the arm.
incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even
And
though there
that's
was
what the defense is
absolutely no
arguing.
claim or evidence whatsoever that a dog caused these wounds.
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can
Oh
you?
boy.
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
That's
Did
in
you consider
evidence.
that?
I didn't know that at the time.
Could we have 201D, please?
Do you know that now? Because that can be considered.
Dr. Russell, this is a photograph.
I'm not mad at considering things that are in evidence. I'm real mad about trying to consider things that aren't in evidence. It's just okay. They're approaching about the fragments. This is going to go much longer into the day than I think anyone anticipated with this cross-examination, and the redirect is probably going to take the rest of the day. I thought we would be done with this witness pretty quickly.
Dr.
Nope.
Russell, were you
Not at all.
aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions
Emily, what are you looking at? My rules
were
of
not
evidence.
caused by a collision or an
I have
impact?
questions.
After.
And when you learned
I'm a
that,
lawyer. We go to books.
did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
What?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know
What?
how Mr. O'Keefe fell to the ground and what movements his body and arm made?
I'm whatting the question, not the response. But how are we getting to, did you consider that microscopic debris caused the scratches?
As he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like
What
this
is happening?
could not have caused the superficial abrasions to John O'Keefe's arm?
Yeah, that was her.
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to
Really?
ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
She was.
I have no further questions.
Mr. Alessi?
Thank you, Your Honor.
And we're at the end of cross. I am surprised by a lot of the questions. I am not surprised by the answers. I am surprised at how long Brennan spent in the weeds on tooth marks versus claw marks versus tooth marks versus claw marks. He did ask about the ultimate, I guess, conclusion of the Commonwealth, which is, what about the taillight fragments? He asked, did you consider these pictures? And she said, no, I considered that there were taillight fragments, but I did not consider these specific pictures. You know what he didn't ask her? He didn't ask her specifically about whether those large pieces of taillight she considered to cause the injury. She asked if she considered the pictures, and he talked around it, and then asked about, did the microscopically viewed pieces of debris from the sweatshirt cause those scratches? And she said no. He did not ask specifically about the taillight causing the abrasions to the arm. He did ask if she considered it, and she said, yes, I considered glass, plastic, or metal could come from a car accident, and I considered whether glass, plastic, or metal could cause that type of injury, and it wouldn't cause that type of injury in those parallel lines. So she answered it, but there were questions he specifically did not ask, and then questions that he specifically did ask. And so as I was looking back through my rules of evidence, because we needed a minute to look at the rules of evidence and what experts can testify to, we got into the basis of an expert's opinion, and an expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. So if she was aware of the DNA, then she can consider it. If in the expert's particular field, it would be reasonable to rely on those kinds of facts or data. That continues on to say, if in a particular field, it would be reasonable to rely on those kinds of facts or data in forming an opinion on the subject, they need not be admissible for the opinion to be admitted, which I imagine is what the sidestep to that's going to be, that is admissible. It's just not been admitted. But if she relied on it, she can be asked about it. But if she didn't rely on it, she can be asked about it. But if the facts or data would otherwise be inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value would help. This is admissible evidence. It just wasn't admitted. And I think that's the direction that, well, I think if this was ever conformed to writing, that would be the argument that would be made in writing, that this is admissible evidence. It has not been admitted, but she considered it, and therefore she can explain, well, why she considered it and then formed the opinion that it was not relevant here. That's the direction they will go in. These decisions in trial are firmly within the sound discretion of the court. So when looking at that evidence section, that is going to fall on the discretion of the court. It doesn't mean I like it. I don't like it. And I think that the jury will probably be like, but if it's so critical to you, Brennan, why didn't we hear about it? I'm interested to say where we go with redirect on that, because it opens up the entire door for her to just clamp down on why she didn't consider that evidence. It's a wild strategy.
Okay.
I hope I made it clear. It doesn't mean I agree with it. I can see where the argument will be. And I think, again, if it's so critical that I can't get past, if it's so critical that she consider it, if it's so important, then why didn't the jury see it during their case in chief? But it gives Alessi a lot of room to say, so you didn't consider that there was no dog DNA. Why didn't you consider it? And let her explain, well, these are all the problems I have with it. And then, if these are all the problems you have with it, how does the defense not argue, right? These are all the problems the expert had with it, and the prosecution never even showed it to the jury. Just wild. I do not like the sidestepping of bringing that evidence in. I don't. Is it within the discretion of the court to allow him to ask those questions? Yes. Do I think it will end up biting him? Yes. But does the earlier answer about grief get a little bit lost? Maybe, maybe not, because the jury has their notes. There's a lot of room here for redirect. We will see if Alessi keeps the redirect concise with short, simple questions or not. I hope that it is concisely phrased.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
I think there were definitely some big
Dr. Russell,
errors in that.
I have
cross.
up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201.
There's a great question in the chat that I was trying to grab, and it flew by, and I didn't get to grab it, from Lee, saying, EDB, since it's not in evidence, does the jury have access to that information in consideration of the verdict? I think it's a fantastic question about how the jury can consider it. They can only consider it in connection with this expert's opinion. So they will get jury instructions about expert opinion later, and they are told that what the expert considered or didn't consider can go to the weight of how they consider the expert's opinion. But it doesn't go to the evidence in the case. It only goes to the expert opinion. So this all goes to the weight and credibility of the expert opinion. That's why we saw Brennan harping on, you didn't consider this, you didn't consider this, you didn't consider this. They are going to argue, hey, look at all the things this expert didn't consider. And the defense on the flip side of that will be like, well, this is why the expert didn't consider it. So it goes to the weight and credibility of the expert's ultimate opinion. Like, do you agree with this expert's opinion based on what she considered or didn't consider? So they can't consider it as independent evidence. They can consider it as to the expert's opinion. Hopefully that helps. I know it seems like a distinction without a difference, which I think can be hard for jurors too, is the way they're allowed to consider certain things.
An E.
All right, so now we're into the microscopic
With regard
shards.
to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So
It's
let's
so
go back
hard.
to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are,
The jury knows that.
again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right.
This is the danger of this, is that we heard the expert testimony that this photo was taken through the microscope. But this expert doesn't know that. And I don't know if there's a picture of just when they open the tin what it looks like. I think that there is. But this photo was taken, I think, under the microscope. If not under the microscope, then under an extreme zoom, as you can see by the ruler. So it was under magnification. Thank you, Lyndon. It was under magnification in some way. But I don't remember the exact testimony about these photos because it's been so long ago.
Right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolf, one more time. So these
I don't think they ever went
pieces
through
are
this
a
with her.
16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolf, now go to Exhibit 1.
A number of you have asked
Attorney
the same
Brennan
thing.
asked you several.
Are these are the scrapings that were from John O'Keefe's hoodie. So they are scrapings out of the hoodie that were put into the tin and then photographed later.
Several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would
Chat,
like
yes,
you to
hoodie and
answer
shirt.
whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer,
did the
are
wounds have to be
oriented in this direction a little bit.
Wouldn't they
Well,
be in
anatomically a
the wound?
little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Alessi.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Her face
Not
said
at all.
no. Her face said nope. 100%
You were asked
no.
several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Objection.
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions
Yeah, like
by
100 years
Attorney
ago,
Brennan,
yes.
and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology.
Is there one? No. The methodology
You
is pattern
referenced
recognition. All of medicine.
studies and as part of your answer, do you recall that discussion with Mr. Brennan?
This group
Yes.
of symptoms goes with
Do
this.
those, and you, are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties
So
of
if we
the
could
authors.
just- I'm sorry to interrupt you, Dr. Russell.
I'm
You
sorry.
finished?
The specialties of the authors, yes.
If we could take that down for a moment. Your Honor, may I approach, please?
Okay?
If I could have, Your Honor, from Madam Court Reporter,
Okay.
exhibits marked for identification PPP and QQQ. And I'll start with PPP if I could, please.
We're back to PPP and QQQ, marked for identification, which are the articles by DeMunich and Pollock.
Thank you, Madam Court Reporter. May I present PPP to it? Thank you, Your Honor.
So,
Dr. Russell, you
Items
have
pew,
for
pew,
you
pew.
PPP, is that the study with the lead author, Dr. DeMunich.
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog
Questions are
wounds?
too
Do you recall that?
long.
Yes.
Can you please take a look at Exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine,
I don't know.
and it is entitled.
I don't know how much the jury's going to care about the methodology or not. It's about whether this testimony makes sense to them. Does it make sense to them the way she's explained that these injuries can happen or not? Getting into the rabbit hole of the methodology, I think is going to get too in the weeds. I hope that they do get back to why she did or didn't consider the DNA, why she did or didn't consider Karen Reed's statements, what she considered about John O'Keefe's sleeve. I don't think going through, well, this study said this and this study said that is going to be helpful to the jury. They're just going to start to go, okay, but what is it?
Titled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns?
She's like, no, I'm going to keep teaching these
This
girls
next
about
paragraph.
all of this.
The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite, in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex, can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites. especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
Objection.
That's sustained.
What do you conclude from the language you just read in that
Well, she's
study
like, that
with regard
describes
to
it.
methodology of discerning?
She's like, that describes the teeth marks and the claw marks and why the things are together and why the grouping of things can go to a dog vis-a-vis a different animal.
Dog bite wounds.
That pattern recognition is very important.
And that certain patterns are typical,
Now what I would
even though the type
like,
of
if I could
wound
approach Your Honor.
might vary or the look of the wound might vary. That's what I take from that. Though there aren't any puncture wounds here, which I'm
If I
sure
could
Brennan
return
will
this to Madam
highlight
Court Reporter
when he
and
gets back
please
up to do
request
recross.
Exhibit QQQ for identification.
We're on to
Madam Court
QQQ.
Reporter, may I hand it to the witness?
Yes.
Thank you, Your Honor. I've now
Emily,
handed you what is
why are we on
marked for identifications
QQQ? Because that's how many things we have seen. The exhibits that are entered into evidence are marked for identification first. Exhibit 1 was marked for identification first as A. So it's A, then it gets moved into evidence, and then it becomes evidence 1. So we have now gone round through the alphabet to get to 3 numbers, and that is why these are marked for identification, so they're identifiable on the record, but these are not in evidence, so they do not have an evidence number. That's why we are on PPP and QQQ.
Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yeah, there
Yes.
were punctures on the, I
could
think there
you
were punctures on the
please,
clothing.
As
And
you
she said
did
that
with
very
the
clearly
Munich study, can you
about the clothing.
please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes, so this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child, and they described the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern.
Right? Reading out loud's always awkward. And then when the sentences are awkward, it gets worse. And she's like, they could have written that better.
Of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
Reading out loud is hard.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted.
But would you
If the
consider
shorter
these sharp-edged
incisors
wound slits?
leave an impression, smaller skin lesions,
I think that's
parentheses, round
where we're
pressure
at.
marks or streaky glide marks can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is
Do you
that
think he didn't hear
sentence
it?
relevant
Do you
at
think he just
all
wanted her to
to what
repeat
you've
it?
referenced as an incomplete
I'm
bite?
going with number 2.
Yes,
How is it relevant?
because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of
we talk more about that?
interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any? Is textiles mean clothing?
Yes, and I thought
Was
you
the
meant in this
decedent-
article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt
Please
or
continue.
sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I don't want to
keep on reading.
keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this.
I hope they ask more
And then
about.
there's one section that said.
Thank you.
I hope they ask more
thank you.
about the hoodie.
Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell. Thank you, Madam Court Reporter. So do those studies, the de Munich and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
As to the form, Mr. Alessi.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Okay.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall
The
pattern
group.
to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds
Brennan's
with
objecting
respect
to leading.
to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Okay.
Now let's switch topics.
Which topics are we getting to before lunch? Will it be DNA? Will it be the hoodie? Will it be what
Attorney
she
Brennan
didn't consider?
asked you about various considerations you made with
Well, that
regard
could be all of
to
it.
differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that
Alessi, just
process that
ask
you
the
undertook just
question.
generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or
Well, I'd
abdominal
like to
pain?
give you an example of what you used here in this
Yeah.
case
Yeah,
as
okay.
the
Can
you just
application of that.
Tell us how
okay,
you
so
did
I'm
it
just
here.
describing the overall process because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong, and so you have to allow for other information, and so I did that in
Right.
this case. I examined the circumstances, examined the wounds photographically, and came up with my impression, but I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some,
Right.
some news clips.
And did you recall your discussion with Attorney Brennan
ask her questions.
about acute grief reaction?
And let
You
her
remember that
answer.
discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Just let her explain it again.
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame
Just
in
let her
acute
answer.
grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
It is a lot to get to the question. And she answered this on cross. I'm interested to see what's going to come up this sidebar because this was kicked wide open on cross. And I think Brennan stepped directly into it on cross. But Alessi's questioning around this is not very precise. All right, that is a fairly long sidebar. I hope that we get to some shorter questions because Alessi's absolutely allowed to inquire about this. It just needs to be narrowed down in the way he questions about it. So, Brennan opened up all of this. I know, Alessi is verbose like I am. It's just really hard on the jury after such a long morning.
May I
It's
have
got
a
to be
moment, Your
shorter
Honor?
questions.
Thank you.
Because, again, I think Brennan was not prepared for the answer
Dr.
that
Russell,
came in and
do
then
you
moved
recall
on.
questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to?
Nope, that was on me. I was trying to pause it. He moved on. He immediately moved on. And as I was trying to pause it, it just like yeeted itself. But he immediately moved on. Well, I really want to know what happened in that sidebar because that's fair game. Yeah, I really wish I knew what happened in that sidebar because he is moving on about it.
To this supposed accident reconstruction. You remember those questions?
And he's
Yes.
moved on to talking about
Mr. Woke, if you could please
Something
publish
else.
the
I don't
slide
know if he'll
from
come back to
Dr.
it.
Welcher's presentation with the arm out in the glass in the back. Not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back.
there's so
with
much information in that, Alessi,
his
when he's asking him to pull it up. Yikes. I don't know what happened. I don't know what happened at sidebar. So I don't know. All I know is he's moving on. We don't know if he'll come back to it. We don't know if we don't know. And there's been times the judge has said we need to come back to things after whenever. I don't know. But he's moved on. We'll see at the end of cross if he comes back to it or not.
that would be toward
We'll
the back
see.
of that slide presentation, probably around 1:30.
So now we are into the Welcher information.
That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. from your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and
Or
with
an elbow
Your Honor's
fracture.
permission, show where the radius and where the ulnar bones are of the arm? Lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
How about the
The
shoulder?
hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the
Shoulder.
circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood?
I appreciate the circle back because we've seen a lot of testimony and a lot of questioning from the prosecution about this was a clip, this was a side swipe, he was just clipped. But the way that Welcher's lined up behind the car is, the defense is arguing, a direct impact to the arm, even though it's not a direct impact to the center mass of the body. So it's gotten back to, you can't have it both ways. If it's a clip and you've not hit center mass of the body, that might explain why you don't have injuries to the lower extremities. But then what do you expect to see to the arm? Because in all those experiments, the arm was out at 90 degrees directly behind the car, not to the side of the car. So they keep pointing out that while the Commonwealth is saying, oh, it was clipped, it was not a direct impact center mass of the body. Okay, but then where is the evidence of impact to the arm? And bringing it all back around to that, I think, is helpful with this doctor because she has the experience to talk about it.
Of there being any fracture to any bone.
Objection.
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to,
Well, the
as
Commonwealth's
I
gonna
understand
key
it,
in on
you have
laceration, aren't they?
reviewed the autopsy report.
She's going to say, I would expect a significant bruise, a laceration, or broken bones. And the Commonwealth's going to say, well, these are the lacerations. Because she opened up that possibility that it could be this or this or this. And I imagine we'll see that in redirect.
Of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scorbello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scorti-Bello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her for lunch?
Jurors, I'm going to send you out for lunch, okay? We'll see you at 2 o'clock. Yes, come on up.
Okay. Well, it is the lunch break because the court, I want to see if they go back on the record about that before they talk about let's see if they go back on the record. Oh, it looks like they're going up to sidebar instead. Well, the jury's out. Can we not do it at sidebar if the jury's out? Can we just do it in open court? You can excuse the witness. You can excuse the witness. Just let us hear. It's in the autopsy report. It's the best of my memory that the autopsy report is in evidence. All right, I'm going to zoom past and see if they put anything on the record before they leave. And it looks like they are not going to put anything publicly on the record. That whole sidebar, of course, is on the record, but they're not going to put anything. They're not going to get into it in open court more. So I guess we will see after lunch where we go with the different types of examinations and into more detail of the autopsy, which is what they were starting to get into. And again, if you can ask about how she determined that there were no injuries to the lower extremities, if the coroner physically looked, then you can get into it. Might they sanitize it a little bit? No, they've already seen the photos. They've seen a lot of the photos from the autopsy. They can discuss the autopsy. Oh, it's so frustrating to try to explain what happens at sidebar. Well, I can't hear the sidebar. We will see what's going to happen after lunch. Let's see if we can summarize what happened. Today has been a whole lot, just a whole lot. So at the lunch break, day 26 into the defense case, we're 3 days now into the defense case, 4 witnesses. We are on the redirect of Dr. Russell. And we are getting into the different segments of redirect where we saw the prosecution go during cross-examination. This is after, of course, the defense argued for a mistrial with prejudice. The court denied the mistrial with prejudice and allowed the prosecution to continue to ask about this witness's consideration of the DNA results, though the person who tested the DNA and the DNA results themselves are not in evidence in this case, but allowed the prosecution to question the witness about the DNA results and whether or not she considered them. And she answered that she considered why the DNA results might show that there was no dog DNA. And she listed out a few reasons why the results might not show dog DNA. And that was the clothes were not tested for a substantial amount of time or swabbed for a substantial amount of time. The clothes were on the floor of an ambulance. And she listed off a few other things saying, this is why I was looking at whether or not this was a significant finding that would change my opinion about the injuries to John O'Keefe's arm. And she said, ultimately, the fact that there was no dog DNA found on the sleeve is not instructive to her because of all those other factors. We haven't gotten to that on redirect yet. I think that we will. The court also denied the Commonwealth's request to ask this witness about their rebuttal expert's report after a short voir dire of Dr. Russell. And when Alessi got up and argued before the court cut him off and said, no, I'm not allowing it in, Alessi was arguing this is the same circumstance as Dr. Welcher being questioned about Trooper Paul's report and the coroner Scorty Bellow's report. This is the same thing. So she said she didn't rely on it. How can she be questioned about it? And the court agreed with Alessi on that and said, yes, you cannot question this witness about the rebuttal witness's report. So we are now into that redirect, asking Dr. Russell about what she considered, how, and why, after we went through Dr. Russell reading in some of the points from the articles she relied on, talking about what you expect to see with dog bites and talking about the parallel nature of claw marks, talking about what you expect to see with dog bites, talking about the mechanism of dog bites into peer-reviewed studies that were reviewed in medical journals. So now we are at lunch. I am waiting to see if the defense circles back in the area about Karen Reed's interviews with media, because the defense started to ask about it and asked quite a few things about it and then started to ask for more explanation. There was an objection. They went to sidebar, and then he came back and moved into asking about Dr. Welcher's slides study and how Dr. Welcher's positioned his own arm while dressed as John O'Keefe up against the back of the Lexus, and what types of injuries Dr. Russell would expect to see if the arm was hit from, bicep down through wrist by the SUV, and what type of injuries she would expect there, because she said that wouldn't be a glancing strike because the arm is like squarely behind the vehicle. And she said she would expect to see significant bruising, lacerations, or broken bones. I expect we will see the Commonwealth then in their recross try to argue, but there are lacerations here, to which I expect her to say, well, that's not what any of the findings say. It says that these are abrasions, not lacerations, but I don't expect Brennan to skip over asking about that. You said it could be bruising or lacerations or broken bones. I expect that he will key in on that on his questioning when we get to recross. And yes, Brennan will get a recross. I'm surprised that after sidebar, we didn't see Alessi ask more about the area of grief that Brennan elicited the answer from in cross. I don't think Brennan expected that that answer when he said, well, you didn't consider Karen Reed's statements. I don't know how he couldn't, though. How do you not expect the answer when you ask why she didn't consider Karen Reed's statements? I think that was a prime example of don't ask a question on cross you don't know the answer to, because he asked about it and said, why didn't you consider Karen Reed's interviews? And she went thoroughly through, this is why I didn't consider them. It'll be interesting to see if Alessi is able to circle back in it or not. But how do you not expect that that's what's going to happen? I don't know. We're going to answer a few questions, and then we are going to take a little bit of a break for lunch and get some food. It's a retrial. And every day, it's just wildness. Just wild. So, retrial. Whew. Lord. All right. The jury is, well, lunch is supposed to be done in about 10 minutes from now in real time. So I'm going to answer a few questions and then grab some food real quickly. My brain is still buffering at this point because of how much has happened in court today. I don't know why my expectations are now wrong. I expect that court days are just going to follow normal process and procedure, and then they don't at all. And I'm still surprised. I shouldn't be at this point, but I'm still surprised. Insert name here in the chat asked, Emily, do you think Brennan was trying to make it seem like she has memory loss due to age? I don't think so. That's not how I read his question, but I watch court a lot. I've been in court a lot, and you see it asked, I think we saw it asked of Jen McCabe at one point, when you are getting that line of question and answers with, can I see my transcript? You will generally at some point ask questions about memory. Maybe not in that way. You will see questions about, do you not remember what you testified to here? Does your memory improve with time? There are other ways to ask it, for sure. But is it unexpected that we would see that question? No. Was it very close in time to her saying, well, I would like to see my transcript? Yes, it was. Do I think it was snarky? Yes, I do. However, he got caught out yesterday by this witness in saying, well, didn't you say, or didn't you see in Dr. Scorti-Bello's report this and this and this? She said, I don't quite remember if that's in the report, and he goes, well, and asked if she could see the report. And he said, well, it's not in the report, and then went forward. So I'm not surprised that her tenor of answering questions changed this morning. He changed his tenor of cross-examination this morning, and then he got into all of the questioning about, well, did someone tell you you should ask for your transcript because she didn't do it yesterday? And I think there's two reasons for her to do that. One of those reasons is, well, yesterday you said in the report, doesn't it say? And she said, I'm not sure about that. And then you said, well, maybe it's not in the report. So if I'm the witness, I'm now like, oh, so I can't trust the things that you say because you're saying, oh, well, maybe it's not in the report. Okay. But when asked about it, she said, well, I did talk to Mr. Alessi about it, and he said, ask for your transcripts. And that became a whole issue. How much the jury will make of it is up to them. Is it improper? Yes. If it had been a Commonwealth witness, I think people would have just lost their minds in a different way. Do I put the responsibility more on Alessi? I do. Alessi knows better. The witness should also know better. But ultimately, the lawyer has to say, I cannot talk to you in the middle of testimony. You cannot talk in the middle of testimony to the witnesses. The defense made a motion about it. So, yeah, that shouldn't have happened. Could he tell her that before she testifies? 100%. 100% he can tell her that before, but he can't talk to her in the middle of testimony. But we have seen Brennan's strategy here. Brennan's strategy is see what these defense attorneys are doing. Do you see what the defense is up to? They're hiding something from you. Now, that's a real interesting strategy when the Commonwealth has very clearly not called Proctor, has very clearly not entered into the evidence, any DNA results here. There's other things where the defense, I think, will turn that around and say, oh, who's not telling who anything? But Brennan has leaned full into the strategy of see what those defense attorneys are doing. It's 100% what he's leaned into for his strategy. See what they're hiding from you. Real interesting strategy from Brennan, but that's 100% what he's leaning 100% what he's leaning into. I mean, I don't think that is surprising. What's surprising me is how much he questions on cross like a defense attorney, because what I expect to see from a prosecutor is using the cross-examination to narrow down the testimony towards their theory of the case, not using cross-examination to throw in a whole bunch of possibilities. Well, do you know if it's possible that this happened? Do you know if it's possible that this happened? And this and this and this. That is a defense strategy to cross-examination. Is it possible this? Okay. But he has not used cross to narrow down that the only possibility with this witness specifically, the only possibility is that those injuries came from colliding with Karen Reed's vehicle. I do not think he did that in cross. He tried to point out that this witness was an advocate for the defense. He's going to do that with all of the defense experts. He tried to point out that this expert is not a biomechanical engineer. Okay. He tried to go after her areas of expertise and whether or not she had a certificate in accident reconstruction, to which she actually said, well, actually, we did take classes about that when I was in the police academy, which surprised the shit out of me. But of course she did, because if any witness is going to be like, well, actually, I do, it's this witness. He has tried to point out that she has confirmation bias, that she is biased, that she, parachuted into this case because she wanted to be involved, and that because she's interested in dog bites, everything looks like a dog bite, and everything is going to be a dog bite because that is what her focus is on. He got so stuck in the weeds, though, with claw marks versus teeth marks versus claw marks versus teeth marks. We will see what their expert does with it. Because remember, now in cross, the prosecution is setting up their expert and the responses from their expert in rebuttal. What else in cross? There will be some jurors that will not like at all that she was talking to Alessi in between testimony. Some jurors might care not at all. Some will not like it. And pointing out what she didn't review versus did review is a strategy that everyone is going to use with the experts. You reviewed this, not this. It's how they differentiate. So at the end of the day, I think a lot of this testimony is going to come down to what the jury believes in light of everything else. The prosecution's job is to narrow it down so that the jury can say that beyond a reasonable doubt, the only thing that caused the injuries to John O'Keefe is Karen Reed's vehicle. And the job of the defense is to say, it's reasonable that this happened, it's reasonable that this happened, and it's reasonable that this happened. And I think that where Brennan is getting caught in his cross is he is not narrowing it back down to there is only one possibility. Because he keeps pointing out other possibilities to try to disprove this expert. But I think that's getting a little bit lost in the overall what he has to prove. Because he did not spend time narrowing it down for me. We'll see if it does with his rebuttal experts. But it was, all these other possibilities too. And if there's a lot of possibilities, then how can you say which possibility is the reasonable one, the only reasonable one, the one explanation? We'll see how he gets there, if he gets there, and that's up for the jury to decide. If the prosecution has narrowed out every other possibility. I think it's hard with some of their expert testimony, though. Colette, this is a great question. Colette said, but Emily, how did Brennan know they were talking about that in the car on the way to court? He didn't. She told him. He just asked the questions because the way she answered changed. The way she was answering changed, and so he asked her about it. Also, if you look back at the testimony, I have said a couple times now that Brennan does things similarly to Jackson. If you look at other witness testimony that took a break overnight, you see Jackson frequently asking, did anyone talk to you? When did you meet with the district attorneys? Did anyone talk to you yesterday? It's not an uncommon question. He didn't know what the answer would be, but she told him, and that's why he started following up on it. He didn't know. He just started asking. So did you talk to someone? But it's a really common question over the break. Did anyone from the defense team talk to you about this case last night or over the break before you resumed testimony? And the defense asked numerous Commonwealth witnesses about it too. It's a very common question. And she didn't see anything wrong with it and said, we didn't talk about the case, but yes, we talked. He told me, and whatever she said about being able to ask for transcripts. And she said that wasn't us talking about the case. And Brennan didn't, kind of surprisingly, lose his mind and call for a sidebar and ask for sanctions and all the rest of it, which actually kind of surprises me. He took a lot of stuff in stride today, like in kind of a surprising way. Just a lot of things in stride, which surprises me. JR said the arm wounds can't be lacerations and be superficial. I don't disagree, but I suspect, and I see it as one of the things I process with you guys or share is where I think the attorneys may go, because I'm curious to see if that's where they go, I think he will. I don't disagree that lacerations and abrasions are different. I think that that's where Brennan will go in questioning. He might not. We will see. Adrian said, EDB, squirrel brain for me today. Thank you for the breakdowns. No worry. Today's been a lot. Yesterday's been a lot. This case is a lot. All the things are a lot. So all the things are a lot. It's totally fair. My dog is my ears, said the dog bites. I do believe they are with 40 years of working with canines. That wasn't the cause of death. He had massive head wounds, not one area. So it's just part of it. The dog is my ears. I don't disagree with you. The reason that the injuries to John O'Keefe's arm are critical is because the Commonwealth needs to prove that there's only one option for what happened to John O'Keefe. The defense wants to prove that there are multiple options to explain what happened to John O'Keefe. And saying that the lacerations, or I should say the injuries, because now I am stuck in a loop, but saying that the injuries to John O'Keefe's arm had to happen from the vehicle gets harder when you have experts coming in saying, no, these look like dog bites. These look like dog bites and scratches. So are they dog bites and scratches, or are they from the vehicle? And when the jury is told if there are two reasonable options or outcomes, you must pick the one that points towards not guilty. Is it completely unreasonable that the injuries to the arm come from a dog? Or is that a reasonable possibility? And if that's a reasonable possibility, that alone for some jurors can be like, no, we don't know what happened to his arm. It's reasonable that it came from a dog. Therefore, I can't say it came from a car. And then they evaluate the other evidence. And then you have Dr. Wolf, hungry like us, saying, yeah, I see these types of head injuries to the back of the head all the time when people slip or have a heart attack and fall backwards. And then you have Dr. Welcher saying, yeah, we looked at these studies. And when you drop a test dummy just from standing height backwards, they get similar types of injury to the back of the head. All of those mean to me that the Commonwealth can't argue that the only way this happened is from being struck with a vehicle. There are some injuries in vehicle collisions where you look at the injury and the only way enough force is generated for that injury is from a vehicle. But I think the Commonwealth experts said clearly that this type of head injury doesn't need additional force or inertia from a vehicle. It could happen from a standing fall backwards. And that becomes a difficult thing for them to overcome in this case. And I think they are trying to overcome it with Karen Reed's words. The defense is going to say, okay, well, if this is reasonable and this is reasonable and this is reasonable, then we don't know. And the investigation didn't shore it up for us. And the Commonwealth is going to say, Karen Reed said, I hit him. Could I have hit him? I clipped him. And our experts say that she did. So that's where we're at with all of it. This is a great question, F. Marsh. Does the jury know about the dog in the Alberts house? Yes. Briefly, but yes, they do. And they heard from Sarah Levinson that she was very close friends with Brian Albert Jr., but had never really seen the dog and had not been around the dog. She knew they had a dog, but she hadn't really been around the dog as a close friend, and that being her close friend's house. And they heard from Trooper Buchanan that the Alberts had a dog, the type of dog, that the dog no longer is with the Albert family, that the dog is in Vermont, that the dog has had a name change. There was a lot of information from Buchanan about the dog. It was like this and this and this and this. But the thing that stuck out to me about the dog the most was Sarah Levinson saying, yeah, this is my close friend's house, and I didn't see the dog. I don't remember seeing the dog that night. And there was a lot of questions about who saw the dog that night or didn't. So let's see. Greg S. said, did Judge Cannoni not allow the defense to explore the post-trauma statements? I don't know what happened at sidebar, but he didn't get back into it. I am going to take, well, probably about 5 minutes. 10, we'll take 10. We'll take just 10 to grab some food because I have answered questions way too long. I think there's a lot of questions today. I also think, for me at least, there is some fatigue today in how much we got into the weeds in some of these areas of particularly cross. Because there were areas of cross where I think Brennan got the answers he wants to argue down the road. But there were areas of cross where it just went so round and round and round and round and round. It was just absolutely exhausting. So I'm going to take 5 minutes. It is 1:06 my time. I will be back at 1. I will say 1:15. I might be back a little bit sooner if I can get lunch sooner. So I'm going to go grab food. Court will be back shortly. I'm going to grab food and turn my fan on. Y'all don't forget to hydrate. Today and yesterday have been so extra. And does it signal for you? Let me know in the chat. Does the amount of time that Brennan is spending on cross of this witness signal to you what? Just the amount of cross seems to be an indication of how important he thinks his testimony is to me. Let me know if you agree or just think he got lost in the sauce wanting to fight with this witness. I want to know what you think about it. Let's get to a real quick lunch break. I will see you in a minute. Mods, don't forget to take a lunch break. Don't forget to take your breaks. Thank you, everybody. I know it's a lot today. It's a lot. So, quick break. Maybe we will pick different music. Emily, what music do you want? I don't know. We're going to find it. We're going to find out together, chat. We're going to just pick something different and have some fun. All right. I'll see you in just a minute. Don't forget to download the Lawnerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnerd app has all of your live court notifications to keep you in the loop. LawnerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Hopefully we enjoyed the lunch music and the lunch break and you got some food. I had a chance to cut up some fruit because it is hot here and that's what we're doing for lunch. So we're on the redirect. Dr. Russell, I expect that we're going to be here for more than a few minutes because before the court's ruling, Alessi said he had about 30 minutes. I anticipate he's got a bit more than that. So we will see. I saw a couple questions come in over the lunch break. Hannah said John's clothing wasn't swabbed on the sleeve. I believe it was swabbed on the sleeve in multiple places, but it was all swabbed on one swab. That is my memory from the scientific testimony of swabbing the sleeve, but it was swabbed in a few places, including the sleeve, but John O'Keefe's injuries were not swabbed. So that the injury was not swabbed. So let's see. Heather said, when Brennan mentioned the bushes, my immediate thought was, oh, is he now saying John O'Keefe got scratches from a bush? Right. And that's the thing. In a lot of Brennan's cross, it doesn't feel like he's narrowing down the possibilities. It feels like he's throwing in new possibilities. That's how I read it. So it might not be, but it's just this, it's just so much. He's just like, it could be this, it could be this, it could be this. Well, sir, can you tell us how it happened? Your job is to narrow it down. And it doesn't feel like on cross he's doing that for me. Narrowing it down and just focusing on the one thing, which is, again, why it feels like the more of a defense style cross of, did you consider this? Could you have considered this? Could it have been this? That is the role of the defense. So let's continue on into this redirect before we get to recross, because court is back in session. So let's go back to court. Hopefully everyone had a good lunch. Let me know if it's lunchtime where you're at. If it's not, I hope you had a good whatever time of day it is where you are, where you're watching.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically,
lower extremities.
We were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities. And to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, if people don't know how autopsies are done,
directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the
see the bones.
bottom of the legs near the ankle. and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but
you can
I
tell
specifically
bruising on the
looked
different
at
levels
the
of
area
tissue.
adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age
So
of
they
that
will
abrasion?
look.
I could.
They will look at the different layers of tissue to see how far into the tissue an injury goes.
Not.
No further questions at this time, Your Honor.
Oh, okay.
The judge is as surprised as I am. Did you hear the judge? Oh, okay. Emily, he's probably got a long way to go. 2 seconds later. No further questions, Your Honor. What? I wonder what discussion was had during lunch. She said that the small abrasion to the knee had no injury in the layers of tissue below it. And she was asked to evaluate the age of it. That was the last question. Okay.
Kate, I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay.
Oh, okay. Okay.
Could I inquire about scope?
See you at sidebar.
Well, Brennan said, can I inquire about the scope? Hey, Brennan? Look, recross has to stay within the scope of redirect. I wonder if that was part of the strategy over the lunch break of limiting what Brennan could ask about on recross. Brennan's aware of it. Can I inquire about the scope of recross? Though you generally just start asking the questions and not asking the court for guidance on the scope. If you think there's scope, ask it, get objected to, and then deal with it. Oh, wild. All right, let's get past this sidebar. To the fan. Really? Okay. It's a long sidebar. Goodness.
May I?
Yes.
We are now on recross.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
I don't think that's ever what she said. I think she's always said it's pattern recognition.
I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Alessi had you look at a couple of case files from the Journal of Legal Medicine,
Those weren't
let me
case
ask
files.
you
Weren't
about
they
that.
studies?
You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question. So we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply
She
for
answered
diagnosing
that.
or
You just don't
looking
like the
at
answer.
a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alessi gone over these articles with you before?
Oh my goodness.
Yes, we
Alessi.
discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alessi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Could we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
And again,
Yes.
And it was
we
a
talked
neck
about
wound from which
we talked about Brennan leaning into, oh, the defense did this. Oh, the defense highlighted this. Oh, the defense pointed it out. And there will be jurors who that is effective for. Oh, you're just reading what they highlighted. That's why he's pointing it out. Because unless she highlighted it and gave it to him bringing it up that's highlighted has a different perception. That's why he's bringing it up. Similar to Alessi bringing up his expert continuing to read off of the computer. Your Honor, he's continuing to read off the computer.
she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Mandibular.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is
But
a
if they
puncture.
don't
If you go
puncture,
into
are they
scissor,
anchored?
It requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. The way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see one or two things that shown up what I think might be.
He has now conflated what they are describing as a scissor action or Emily, leave it alone. The hinging of the jaw, the lower jaw. Now he is calling it, instead of a type of jaw movement, he is now calling it a type of bite, which is confusing with Brennan because he is interchanged in scissors and in incisors numerous times. So I am finding him hard to follow because the hinging of the jaw vis-a-vis the type of bite is confusing. But for all of you who are with me in the same, we're all just like, yes, okay. We're just, yep.
Be upper and
We're all
lower.
just
So
We're all just
It
doing.
could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier
Are we talking about jaw movement or a
how
type
these
of
marks
bite?
here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper
Yes,
and
I'm
lower
singing "Take Your
teeth.
Mama
I'm
Out" tonight.
asking you
I am.
about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So
I-
when you look at that, can you point whether there's any wounds
so
that are consistent with
confused.
scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity. I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
What?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing
Can
or
we go to
tearing
the attorney or the witness,
in
please?
those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and
And
I'm
I'm-
asking you about it.
And she's
Yes, and I'm trying
answering.
to explain so that nobody gets nobody misunderstands
misled.
this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone,
There
on
are-
that wound.
The
Okay,
second
there
they
are
said
no
it in the
punctures
article.
on this
The
arm that
second
I
they
see.
said it in the article,
However,
I thought we were going to get
again,
back around to that. There are no
the
punctures
wounds
here.
Don't have to have every single characteristic. It is, it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr.
It's
Russell.
cross.
So you can maybe ask her.
Specifically,
It's cross.
this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing
But-
this article,
To his point, if an article that you are relying on sets a standard with, even though he's arguing that it's not a standard, which is getting very confusing because he's like, this article doesn't set out a standard, but this article says there are 3 common characteristics, but there's not a standard. But then because these 3 things that are characteristic are not present, then isn't your method unreliable? He tries to say, have it both ways constantly. If you want to say these characteristics aren't present, then say this article lays out 3 characteristics that you see in dog bites. And these 3 characteristics aren't present. Instead, he tries to say there is no standard, but if there was a standard, it would be this, and this case doesn't match it. It's just pick one. Just pick one. Pick one. And if you're going to say this case doesn't match the article that you're relying on, fine. But you can't say that the article's unreliable first and then do it. It doesn't make any
on
sense.
the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alessi had you read, that is
Alessi.
describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the... No, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Alessi?
So the article's now in evidence? Okay. Did you hear Alessi? I have no objection, Your Honor.
210.
Go ahead. Brennan's point would be easier made if he said, so this article is what you're relying on, and this article says there are these 3 characteristics, and those aren't here.
In the other article that you read
Okay.
from,
So this
that was
this doesn't
highlighted
match.
as well.
That's not
Who
what he's
highlighted
doing.
the portions you were to read?
Mr. Alessi.
It's in evidence now.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do
Do you
that.
see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
Are you going to introduce this one into evidence too?
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed
She also said
when a
laceration.
person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the
That's
source of your
argumentative.
material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alessi, and that's why I'm pressing you on these issues.
Sustained.
Do you know, you don't know.
That was argumentative on the opinions on behalf of Mr. Alessi. That was the issue with that question, which is why he is moving on. But I don't think this is going to be helpful.
The movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there.
She's
to
like,
give
I
that
can
type
see
of
the injuries.
information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about
The injuries to the
these
arm.
wounds caused by a motor vehicle collision.
So you would
Right.
agree with me, you are not in a position,
No, that's not what she said.
based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event.
No, I disagree.
And
so
that's
you
not what
think
she
you
said.
can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr.
Is
Brennan-
that true?
I have no details about the
He's getting
collision.
pen-
About what
pedantic.
happened
He's
during
just
the collision. You have no details about the body movement,
playing word
the
games with her.
placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise, it depends on the location, it depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So
That's an interesting line of
if a person
questioning.
was lying prone in the cold winter on the front yard in the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there
Also,
will be
yes, he said
a
prone. I don't
gradual
know why.
lowering of the body temperature and gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
So the objection sustained.
When you came to your conclusion, considering what you see in this picture, and Attorney Alessi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Sustained.
That one is outside the scope.
Finally, Dr. Russell,
I think the
you
questions
said
about
during your
the temperature,
differential
though, are good
diagnosis, you
questions.
consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces,
What?
a person by the name of John C. Walsh, correct?
What? Yeah. What?
I'm going to allow that.
Wait, what?
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Welch and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Argumentative.
Sustained.
You don't know what his scope of
Sustained
practice is, do
immediately.
you?
No, but I always look at where the person works that writes a report in terms of physicians and what their possible experiences are. You know, they work in a medical examiner's office in Alaska or Hawaii or a big city or a little town. I look at those things.
Whether
You
they use the
consider
armpits or not use the armpits.
His opinions after his review of these materials. Did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not
Why is he
photographically
asking
appear
about
to
this?
be, nor are described as puncture, bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I
Did the
had to
ruling
consider that
change at some
and weigh
point?
it.
I have no further questions. Thank you.
What in the world?
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Leaving.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
Right, the totality
In
of the wound
terms
pattern
of,
is what's considered, not just one,
Attorney Brennan
one
asked,
injury to the arm, all
so
of the
now,
injuries.
with regard to the Pollock
Right.
article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you
dynamic.
apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin, and there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Welch. May I approach, Your Honor?
Okay.
Well, I have no idea if the ruling changed, if that's what they were at sidebar about with scope. I have no idea, but
Okay.
Brennan was asking about it.
Yes.
We saw the court rule it out, then we saw
Yes.
Brennan ask about it, and Alessi didn't jump out of his chair objecting, so I can only presume that something changed at that extended sidebar. What that was, I don't know. Why that was, also don't
Back a
know.
little bit.
But I trust that Alessi is A, listening to every question, and B, would jump out of his chair yelling, "Objection, Your Honor," with the disdain of "Objection, Your Honor." He only objected at the beginning, and then that question was rephrased. He didn't object through the rest of the line of questioning. So something changed that. He also didn't ask to approach. So there's a ruling there somewhere, because he did not object on every single question, and he did not approach. So somewhere that ruling must have changed. So he objected, I think, to maintain it for the record, but we didn't see him approaching on it. We didn't see him objecting to every question on it, and we didn't see him yelling, "Objection, Your Honor." So something changed at that sidebar.
Dr. Russell, what I would like to do is to give the jury a fair...
So now they're getting
I'll-
back
I'll
into it. I
withdraw
don't know
that.
what changed.
Commentary, I'd like to be heard.
Why don't you bring the reports over?
And now Brennan's asking for a sidebar. Something changed. And they're going back to sidebar. All right. And back to the fan. He asked about it. He asked about it.
Tell me the name because I need to.
And they excused the witness from the stand at some point because now she's back up at the stand. I don't even know what happened. What in the world is going on?
May I return next to the witness stand, Your Honor?
Yes.
Thank you. May I proceed, Your Honor?
Yes.
Thank you. Dr. Russell, I am re-handing you this letter with from Dr. Welch, and what I am
And
going
now we
to
are
do,
back
and you just tell
after
me
the
if I do it
sidebar.
correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
So they approached, and Alessi was allowed to read in another finding that without more information, the other pathologist, Dr. Welch, said that there was another undetermined cause of death. So Alessi wanted to read in that part of the report, I would imagine, to counteract the parts of the report that Brennan read in, which Brennan was allowed to read in. So that is all coming from it sounded like he said Dr. Welch, but not Dr. Welcher. This is from the different pathologist who is a rebuttal witness, and the court had ruled that there was no foundation for it. There was another sidebar intervening. Brennan got into it a bit, and then Alessi got into, am I reading this properly? No manner of death. So he used that, he used what the Commonwealth got into to again read in that a second pathologist said that there was not enough information to come up with a manner of death. I'm going to back that up again because I think he only said manner of death, not cause of death, but I wanted to back it up and hear it.
Reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor.
He said cause of death,
All right, Dr. Russell, you are all set.
not manner of
Thank you.
death. That even goes
I'm
beyond
going to have
undetermined
this
manner
marked
of
for
death
Identification.
versus an undetermined cause of death goes beyond an undetermined manner of death. Again, the cause of death being the head injury or the hypothermia or what have you. The manner of death being homicide, accident, undetermined, natural causes. So that went beyond, and she said he was reading it correctly, to say they could not attribute a cause of death even. Okay. So again, too many factors to find one specific cause.
Thank you.
And why in the world would the prosecutor start digging around in that report if the ultimate conclusion of that report is, you know, there's not enough information here to determine a cause of
And
death,
the next
in
witness
addition to the
is-
undetermined manner of death?
Who's the next witness?
If I may, Your Honor?
Yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay, thank you.
And the defense is calling their fifth witness. Again, it seems that often Brennan is trying to win the fight in front of him with losing complete view of the overall battle. He is very much focused on winning these small interactions, but I don't often see him as moving his case forward. All right, we have Officer Barros back on the stand. He did testify in the first trial.
All right, Mr. Jackson, you are all set.
I will just put in a word of, for everyone in here, and there's generally about 20% of you that haven't watched this case before, I am truly doing my best, as are the moderators, to prevent spoilers, especially from witnesses from the first case. We are trying very hard. So for everyone who has seen this testimony or know what this testimony is or know what this officer has seen and done, there is a good portion of our Law Nerd audience that has tuned into this trial new now. So thank you for letting them all watch the information unfold as it does. I appreciate it because it's very helpful, I think, to see how people watching this for the first time who don't know a ton about the case are perceiving it. I find it incredibly helpful, and I love that there are so many of you here that are watching this unfold for the first time and giving us your opinion vis-a-vis those who have watched it now for the second time and seen the pretrial motions. There's a lot more just information there to dig through. So thank you. Let us continue.
Good afternoon, sir. How are you?
Good afternoon, sir.
Witness number
Could you
5.
please state your full name, spell your last name for the jurors, please?
Nicholas Barros, Barros,
And where do you currently work?
the town of Dighton, Dighton Police Department,
How long have you worked for the Dighton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I I supervised the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts
Dighton
State Police, or is it an
PD.
autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your
I
duties...
think in this case, it's important to say Dighton PD is separate from Massachusetts State Police. They're not working in the Norfolk DA's office. They are not part of Canton PD. They are not part of Boston PD. Dighton PD is its own police force covering that city. Continuing on.
to oversee subordinate officers in their daily fare, whatever that may be.
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the Detective Bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right.
Okay.
As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are.
You mean like if you see somebody walk into a Sally Port for a weirdly long period of time, you remember that you saw it? You mean like that? Is that notice things, write reports, chains of custody? I'm very curious if, because this officer is a witness to other things in this case. I wonder if we will see the defense also using this officer with his background, training, and experience to talk about proper police procedure. He's not related to Boston PD. He's not related to Canton PD. He's not related to Proctor and any of the Proctorness. He is a independent witness in the case, which means he has a reason to be here in the case. But are they going to ask him about trained observers, how to interview witnesses, and all of that? Since so far the court has denied them being able to bring in a police procedure expert, using a police officer who's not connected to any of the rest of these agencies makes a lot of sense. It makes a lot of sense. Plus, he's a witness to other parts of this case, which we will get to. So I wonder if we're going to get more police procedure and background training and experience than we normally would for someone who saw kind of a narrow part of this case.
In the police academy, we are told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know,
Accurate.
is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Right. You don't know any of these people, right? Right. We're going to see a
Did
bunch
you
of you don't know
any of
these
the
people
witnesses or
questions, I
individuals
imagine.
involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location. I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dighton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual?
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dighton.
The address being Karen Reed's parents' house.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger?
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barros, did you, I don't want the address, cameras are rolling. Did you respond specifically to a residence in the city of Dighton?
I appreciate the mindfulness.
Did you at that time know
The
who
shit's
lived
been out of the
at
horse
that
too much on that
residence, who
one. I
resided
wish
there?
I did.
they were more mindful.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dighton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
30 is when he first called me and said that they were coming to Dighton to retrieve a vehicle that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you.
So from
what was your role?
So from 2:30 p.m. forward on January 29th, 2022, Proctor is calling Dighton PD saying, we are coming into your jurisdiction to retrieve a vehicle that was involved in a homicide. Right.
Once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing. Did
Diamond Towing ultimately show up, a representative of that
They did.
tow company with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry,
Fair.
My fault.
The court
Let's start
reporter
that
told
just a
Jackson
little
to
bit slower. Did you
slow
know him?
down.
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
I mean, he speaks
What were you
quickly
driving?
too.
I was driving a Ford F-150 police cruiser.
You have a Ford
police cruiser
F-150
that's a Ford
police
F-150?
cruiser?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works.
The whole works.
But you But you have a Ford F-150 that's a police cruiser. Oh, that's funny. But here's the thing. Where you live is going to depend, or is going to really change the type of equipment that first responders have. In California, you're not going to see a lot of F-150s as police cruisers. They're just not needed, and I'm sure they get terrible gas mileage in traffic or something. But in Massachusetts, where you're dealing with snow and all kinds of different areas, I can understand why you would need different kind of cars. You're seeing all different kind of cars in all different types of jurisdictions, and everybody's starting to roll out like really, really fast cars, which is what we've been seeing with Highway Patrol here. But again, it's the most LA thing, I guess, of both Attorney Jackson and myself to be like, wait, you have an F-150? That's cool.
Have you ever met Sergeant Buchanan before?
I had to
Never.
back up and
Did
hear
you
it
know
again.
him?
I backed up
Do you
way
know him
too far.
professionally or personally?
Never.
Had you ever spoken to him?
He's like, right, I don't know any of these people. I don't know them. I'm not connected to them. I don't know them.
Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
I backed
No
up way too
relationship
far.
whatsoever.
Apologies.
None.
Same with Trooper Proctor.
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Silver said, what's so funny? It's legit. It's funny to me that I said the exact same thing that the attorney said at the exact same time. Like, wait, you have a Ford F-150? That's what's funny to me. Because I said the exact same thing at the exact same time. And then he's like, cool, right. Yep, that's what's funny to me. Not that he drives an F-150 police cruiser. Because, yep.
Full uniform.
Gun, badge, the whole works.
The whole
Different in different jurisdictions.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there. And I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between? Longer?
I would say
Probably not 20 minutes.
Not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant
Before
Buchanan,
it was
correct?
towed.
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight,
Can you describe for the juror, by the way, which taillight are we talking about?
the right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
How did you
Can you
describe
tell us
it?
what that description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big,
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches. or
And
so.
how wide?
That's a big piece.
Maybe that wide, maybe 3 inches, 2 inches, somewhere
Okay.
in there.
That's
I wanna show you
a fairly
photo.
substantial
Your Honor,
size
with the
piece
court's permission, I would like to
missing.
show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight,
Of what?
the Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
That was what I was
Do you see
curious
the
about.
condition of that taillight
Is that
as
how much
it's
was
depicted
missing?
in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's
Or it
different about
absolutely
this
not.
photo, sir?
Again, that's 2 today.
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe
He
specifically,
said that
other than the
taillight
fact
is
that
completely
it's
smashed
different,
out,
describe in
not
detail
how he saw
for the
it.
jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer.
So the middle section was
If
intact.
you can,
The
there's
section
2
towards the side
displays,
was
one
not.
monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the
It would be
jurors.
so helpful if they also put up a picture of the entire rear of the Lexus so you could see the corresponding taillight on the other side. You could see the taillight on the other side to see how much of that is red. So, a lot of you have asked, did he testify in the first trial? Yes. I think on day 22 of the first trial, he testified. He was called by the Commonwealth. And I don't think we got into this much detail with the photos in his testimony. That I don't remember. I remember him saying it was cracked with a piece missing. Now we are quantifying more what cracked with a piece missing means. He testified that the area he saw missing was where that red piece is on the side.
Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
So he's saying that red
Can I
piece
approach?
where the red connects to the top and the bottom on the far side or the outer side of the taillight, he saw that piece missing. And that seems to me, and I am terrible with dimension, so take this with all of the grains of salt, but that dimension of the gap between the 2 red parts seems to be the size that he indicated in court to me. Please let me know if that seems different to you. I'm not great with dimension. But that seems consistent with the size of the piece he saw from the outside of the vehicle, which is consistent with what Carrie said about seeing a piece missing. It was cracked with a piece missing, but not the whole taillight missing. I think when people keep saying not the whole taillight missing, this giant silver part is what they're talking about, the whole taillight. Or at least that's how I've read that testimony.
Yes.
I'm sure we're going to see more pieces.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe
If you
you would
made a report,
remember
it's leading.
if the taillight? Well, let me ask it a different way.
And a number of you have said that is consistent to you with what you
piece
saw
that
in the
you
ring
saw
video.
missing, but not completely damaged, is the reason that you use the phrase "not completely damaged" to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down.
I think you should get into
As you sit here,
other
as you
pictures.
sit here and recall back to that, your observations.
But the
and
questions
you
are
observed this
leading.
for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately,
How did
was
you
the
describe
black
it?
Lexus SUV towed and cleared from the scene?
It's
It was.
leading.
Is it your responsibility or part of your responsibility to log the time that things like this happen? Like, for instance, the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could.
Show him all the pictures.
This is exhibit 105.
I want to hear what he thinks about all the pictures. Just show him all the pictures.
Mention it all. Mention it all.
Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize it as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Barely. Because I
Describe
have the
what you
closed
see.
captioning over them.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission,
Y'all, the way I just want someone to have taken pictures at this point of time.
zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor.
This video was used in the last trial. This is very zoomed in.
Can you see what's depicted in?
What? The feed completely jumped. I was riveted. I'm sure you were riveted. And the feed just went whoop. Y'all, I don't know. I don't know. It means court's probably getting about done for the day. So we're going to refresh the feed and get back to the video that they are showing. At least it's an easy point in time to find. So there's that. Weren't all of you sitting there just going, taillight, taillight? And then the whole feed just went, nope. That was so annoying. All right, we are back in time to that portion of the feed as we are all sitting here watching the SUV load on to the tow truck in Dighton with defense witness 5. I backed up just a little bit as they are getting into
Can
it.
you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area,
Zoom back.
this area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase
It
that?
looks like, it looks to me, and this is the video from the door or doorbell camera at Karen Reed's dad's house. It looks to me like the crack is right close to the top where the timestamp is. That there is a little swoop where there is not red, which seems to be the piece that he is describing.
Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure.
It's the
The
leading.
area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January
Well, now I know why
29th,
Jackson's talking so
2022,
fast.
at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you. Mr. Brennan.
Thank you.
Well, we can see why Jackson was talking so fast during cross. He brought up the video from Karen Reed's father's house, the report from this officer from Dighton, and the video from, or the still photo from the Sally Port, and said, is this photo in the Sally Port how you saw this vehicle when it was picked up in Dighton? And he said twice, absolutely not. There was a piece missing. It was cracked with a piece missing, but the whole thing wasn't broken out. And now to cross-examination.
Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dighton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
They said what they were
When
doing.
you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went
Okay.
inside the house?
What do you mean by spoke to me?
After they introduced you introduced yourself to them, they went into the Reed house,
Yes.
and then they came out.
They came out much later.
And that vehicle was towed.
Correct.
At no time from when you got there until you left did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the
He
damage.
noted the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
Why would he do that?
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at the moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Brennan
So you're
is
taught
talking
the
fast
academy to
too.
use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to
Correct.
say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
He said right rear
To an
taillight.
extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other
right
details of your description
rear.
when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did
So
you
your
ever
memory
have an
improves
opportunity
with
to write
time.
a supplement report? if
How
you wanted to,
long
if you
till that
wanted to give
question?
More detail.
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this
Good
case.
Lord.
Correct.
You came in and you swore under oath regarding your memory,
Correct.
and that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage
I think that
to
was the
that
date.
taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
But were you asked about, to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed,
Time has passed, yep.
that you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed,
Correct.
that your report was respectfully scant,
What?
Correct.
that you had heard a lot about this case since that point, hadn't you?
Respectfully
And so
scant?
considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer, and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about
Well,
a case?
not when he lives
It was in their conference room.
out of the state.
Odd. Go to somebody's hotel to speak to them about a case.
He went to the conference room at the hotel because he doesn't have an office in Massachusetts. But what's interesting to me is that when we said that Brennan was going to ask these questions every single cross, we are now at Brennan asking these questions every single cross. Who did you talk to from the defense? Didn't you think it was weird? Right.
No.
And Brennan has wandered away from the microphone. I will just point out, what's interesting to me is that of all of the law enforcement officers we've seen testify, I think it was this officer and then the officer from the CERT team, whose name is escaping me at the moment, the very first CERT officer, who have answered this way on direct. Generally, this is the type of testimony, or on cross. This is generally the type of testimony I expect on cross. Thank you, Chad. O'Hara. This is what I expect on cross. Yes. No. This. That. Yes, I spoke to Attorney Jackson. Yes, I did this. This is generally what you would expect from witnesses who testify regularly on cross. And we've only seen it from 2 officers in this case. There is no defensiveness. There is no trying to read into the questions more. There is no trying to answer the perceived tone, perceived implication, perceived assumption. There is just a question and an answer. That is it.
Staying.
He told me.
Did you find
I backed
it
up
odd to go
to the
visit
hotel
an attorney
questions.
at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No.
Without saying the name of the hotel.
Brennan said, did you find it odd to go to the hotel to ask about a case? And he said, no. What the chat would like to know, excuse me, to anyone listening in court, the chat would like to know if he brought muffins. The chat needs to know. But did you bring muffins? For everyone who's new to my channel, chat will explain.
Hotel. Where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
Where were you located? I'm not telling you where I live. I'm not telling you. And then he rethought it and went, yeah, did you have to drive? I'm not telling you where I live. Nope. I'm glad the witness was like, no, I'm not. I work in Dighton. Just leave it at that. I work in Dighton.
You took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there,
Saw him on
to the
TV.
hotel, in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end.
The
The good-looking one down there on the right.
No, it was not.
Brennan, what? Did Brennan just say the good-looking one down there on the right? What is happening? What is happening in court today? I'm going to try to gain up the sound. I don't know what's happened. I don't know what's happened. I'm going to have to gain this up a little bit. So he said in the conference room, Jackson, Attorney Little, and now we're trying to figure out whom else.
So you took the effort to go to see Mr. Jackson.
Sorry if that got louder.
Do you know who Mr. Jackson was?
I did.
You seen him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end?
The
Good-looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
I think one of the attorneys on the end, and of course the feed just yeeted itself off the screen. One of the attorneys said, for the record, I'm the good looking one on the right. I think it was Yannetti. Look, man, when there are moments in court that are funny, we're going to play them again. But I think it's Yannetti. I wonder if he stood up and said, I'm the good looking one on the right. Because then you can hear kind of the chuckle in the courtroom. Look, it is late in the day. It is 26 days into trial. And I am not surprised that with that ridiculous questioning of was it the good looking one on the right, that one of the attorneys is going to be like, I identify as the good looking attorney on the right.
Little.
Okay. Who else?
I had to back it up
I'm
again.
not sure of the other gentleman's name.
It was one of the gentlemen right here on the end?
The
good-looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
Yeah, I'm pretty sure Yannetti said, I'm the good looking one on the right, but he was not there.
No.
Were you shown your testimony from the last time you came into court?
No.
The photograph of the vehicle in Sallyport, or the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony,
Oh, now he's back at the mics.
you never, ever,
That was funny.
ever suggested that that was in any way different than what you had seen in Dighton.
Nobody asked me that.
When you were asked to describe
He keeps
the
walking
damage,
away.
and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what...
If you have a transcript of him being shown that photo and then not describing it the same way, then just bring out the transcript. He's asked him 7 times, and I'm being hyperbolic. I don't know if it's actually 7, but he's now asked numerous times. You didn't say that this was different than what you saw. And he's saying, I don't think I was asked that. Okay.
You saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dighton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged. It was cracked, and there was a piece missing but not completely damaged.
Okay.
Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
How is that different than what he said today? How is that
So,
not the
in
same
your
thing
memory,
he said.
in June 10, 2024, was that vehicle's rear tail light had a piece missing, correct?
Correct.
You said that your memory about the damage.
I've really never seen so much impeachment where I'm sitting here going, isn't that exactly what they said? Because I feel like, again, back to The Office, they're the same picture. Like, consistently, it's been, but didn't you say this last time? And they're like, right. And I'm sitting here going, but that's not different. On impeachment, I'm expecting it to be different. I'm waiting to hear the difference. Didn't you say last time, blah, 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 blah? Because you don't bring in prior consistent testimony generally. So where's the impeachment? I'm looking for the difference. And I am struggling because it's, surprise, they're the same picture. Constantly.
To the tail light, as you recall it when you were in Dighton back on January 29, 2022. You said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Are you going to ask, does your memory improve with time? Oh, ask him if he named his water bottle the Yaneti. I'm teasing. Because Alessi apparently calls his Yeti cooler for lunch the Yaneti instead of the Yeti, and he's got a Yeti sticker on his water bottle.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Any approach?
Yes.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right?
Yes.
Ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And I should take a look at there. Could you show me anywhere in your testimony? Anywhere.
The objections are from Ms. State's testimony. I think that's what the objection is, because I remember him saying, not I didn't say that or I did say that, is I don't know if I was asked. That's my memory of the testimony. So that's why the defense is objecting, I suspect.
Where you made any statement about that photo being inconsistent with what you saw in Dighton on January 29, 2022.
A lot of you in the chat are saying that you remember him saying, I don't know if I was asked that. So he's looking at the transcript. I wonder if his answer is going to be, I've looked at my transcript. I was not asked. That would not shock me.
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
Hank's back at the microphone.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah. Correct.
And you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
That's commentary.
You have, as is human nature, difficulties with memory at times. Correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
Brennan's going to use this line of questioning to say,
When
see,
you met with the
he
attorneys
told
in
you.
Boston,
He told you. Because now he's saying, yeah, it's not in there. He told you that he described the differences. He told you he described the differences in his last testimony. And see, it's not there. See, your memory can fade. See, it can be a problem with memory. That's what Brennan's going to use to argue it. That's why the tenor of his questions sound like argument, because he's saying you're not getting up here and perjuring yourself. You just don't recall that that's not what you said in your prior testimony. That's not what you said. But he testified in direct. No, I remember it, and I remember it well now. Though on cross, he's saying, yeah, it's not in there. And Brennan is going to argue it 100%.
Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about? Objection.
I'm going to allow it.
Over here. What did you talk about? Excuse me.
So that, okay.
Oh boy. What in the world? I'm backing up to replay that.
Next months.
Those things all could have been accomplished by phone, correct?
Oh, I backed
Could
up too
have.
far.
So the face-to-face meeting.
Common.
What did you talk about? Objection.
Brennan said in your face-to-face meeting, what did you talk about? There was an objection from Jackson. Brennan's allowed to ask it. The attorneys in the courtroom stand up to object. And then Brennan says,
I'm going to allow it.
Over here.
the court says I'm going to allow it. And Brennan says, over here. Like, I read that as like, look at me over here. And then Jackson says,
Excuse me.
So that, okay.
Jackson says, excuse me, may we approach? He keeps wandering away from the mic. I keep trying to gain down the audio so when he gets to the mic, it's not just ear splitting, but it is hard. And Jackson said, excuse me, may we approach? Because Brennan is again trying to indicate this witness is just looking at the defense table. This witness is just relying on the defense attorneys. This witness went to their hotel to meet with them. That's the intimation Brennan is leaving in his cross, right? You can't touch this witness or rely on this witness. You can't rely on what he says. So Brennan saying over here is an indication to the jury. See, he's looking at the defense table again. Wild. They're back from that sidebar, which took a minute.
You told us there was some background about being subpoenaed and timing. Substantively, what did you talk about with the attorneys when you met them at their hotel conference?
He's just camped out on the back rail of the courtroom, so I'm going to gain him up again. You're allowed to ask about what that meeting was. But again, he's going to try to argue, oh, so you met with the defense attorneys and now your testimony's changed. Okay, well, sir, we all were here yesterday. So...
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No,
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June, early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably, or do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead.
Why not let him answer?
Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January?
Yes.
No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV, and
Was it shown to you during your conference room meeting at the hotel?
it was not.
So you've looked and studied and watched this case a little bit?
That's not what he said.
With all due respect, sir, I don't live under a rock. It's all over
kinda everywhere.
social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations in Dighton on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory? Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay?
It's a bit argumentative. I think he's going to be allowed to rephrase it because what he's his questioning is fair. The way he phrased it is not. The questioning is, could some of the things that you have seen be part of the problem? Is this now your memory? Or are you conflating your memory with things that you've seen? That's the line of questioning that Brennan is going down. And Brennan has moved this witness in his cross from this witness coming across incredibly confident and very direct in his answering to having this witness pause to think about what Brennan is saying. He has been able to shift the way the witness is answering his questions based on his questioning. Some are going to read that as Brennan's questioning style is too aggressive, and some are going to read that as the witness is becoming more hesitant to answer. So it is part of the way that Brennan asks his questions. And we saw it the second a witness pauses, just like earlier today, the second this witness paused, he's like, are you having issues with your memory? It's the exact same thing he did earlier. But if the jury is looking at this witness going, did he conflate it with TV? After the last witness testified, you can see why Brennan's strategy is what Brennan's strategy is. But I'm very interested to see if we get into, sir, you were never asked about that. Like, you were never asked about this. I am very curious because the witness moved from, I wasn't asked about it, and then agreed with Brennan saying, oh, I think I asked about it, and I think I testified about the difference. It's confusing to me that he shifted from, I wasn't asked about it, to, oh, yeah, I guess I didn't testify about it. Very curious. Also, I want to know if he was shown that video last trial, because I don't remember if he was shown that video last trial.
You've seen quite a bit of information about this case and the issue regarding the taillights since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
Wow.
I want to show you some evidence of that taillight before you had a chance to see it in Dighton. If we could have the ring video at 5:07.
He agreed. Whether you like Hank's questions or not, he agreed and agreed and agreed. Yes, the things I've seen have impacted my memory. Yes, I agree. I didn't testify to that in the first time I testified. Yes, I agree that this could have impacted it. Okay.
58, please.
That's his testimony. Brennan has 100% made headway at this part of this cross.
Have you seen this video before, sir?
I have.
When?
Before you proceed, Ms. Gilman. Have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case.
Too many to
And I'm
count.
going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare it to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
Sir, you just said you've seen this video too many times to count. He's like, I'm not searching it out. I'm just seeing it. Well, you've seen it too many times to count? Okay.
I understand. I understand. Please play this, please. Turn the sound down. Thank you. Stop, please. Do you see that white part of the back rear right taillight?
Objection.
Does that taillight look to you more like what we saw in the picture from the Sally port or more like the video from the tow truck? continuing on.
I'm going to allow it.
You see that? Sir?
Zoom in. Go ahead. Just zoom in.
We zoom in a little bit more.
Go ahead. Zoom in. Zoom all the way in.
Mention it all. Mention it all.
Zoom all the way in. Because to me, that looks very similar to to the part of the tow truck. The part of the tow truck being this lower red area. And then we saw the beginning of this missing piece. But does that look consistent with what he testified about to you? However, there is no doubt that some of the jurors are going to be sitting there going, so you've been watching this whole thing on social media and now what you've testified to changed. Undoubtedly, there are going to be some people thinking that. I'm curious to see what his transcript actually says, but does that video look like the tow truck video?
I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please.
And so the jury can see this. The jury can see the tow truck video and him saying this is consistent. Okay.
Continue. Stop. Can you bring it back, Stop?
Zoom in on that then. Go ahead. Zoom in on that, Hank.
Open, right there. Zoom, please. You see, sir?
I can see that.
Okay. Is that consistent with the damage that you saw when you looked at that Lexus in Dighton hours later?
Consistent.
Can we go to Exhibit
And he said
10,
that's
please? And
consistent.
before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day.
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yes.
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dighton, you didn't go over and scoop out any of the snow that was in that
That's a good
broken
point.
taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
Right, he didn't
And
touch
the
it.
Snow that was, there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please.
Brennan made a lot of headway with this witness so far. So you agree that the snow packed into the taillight could impede your ability to see what was broken? He's like, yes.
Does that appear to be
This
the
witness
same
has given
Lexus you
Brennan
looked at
a
when it was in
lot
Dighton?
of room.
And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't. I
We have
can.
Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dighton. Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dighton?
I do not.
The right rear tail light and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay. Lights on, please. Mr. Jackson.
Thank you, Your Honor. I'll be brief.
Jackson is coming up on redirect I think Brennan made a lot of headway on that cross and got this witness to the point where his testimony went from very confident to, yeah, my memory could have been impacted by the videos I've seen on social media. Yeah, I've seen a lot of this on social media. Yes, my memory could have changed. Yes, I didn't remember my testimony from last time, but I didn't intentionally not remember it, but I didn't remember my testimony from last time. I thought I distinguished it. Brennan made a lot of headway with this witness, and his testimony very much shifted to, yes, maybe it was the snow. He does not sound as confident about what is in the Sally Port is 100% not what he saw in the driveway at the end of cross. So we will see what happens on redirect, but yes, it could have been the snow that could have impeded my view. Yes, that video from the One Meadows driveway that is on the dash cam, yes, that looks the same. But he also said that the taillight from the tow truck looks the same and the taillight looks the same from that video at 5:07 a.m. from Reed's vehicle backing out at One Meadows and leaving. So could that all be consistent? Could that all be showing the same thing? Because he said, yes, what I saw that day looks the same as the video with the tow truck, the same as the video from the ring, and the same as the video from the dash cam. But again, that was, I think, one of Brennan's better crosses because he made quite a lot of headway with that witness. All right, let's see what redirect has. He said it'll be short, so we'll see. But again, there's video. So the jury can take a look at the video and be like, do I agree or do I not agree? We'll see.
Sergeant, did you celebrate your birthday 2 years ago?
I did.
Memory. We're getting to memory.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain is to the form, Mr. Jackson, is
Of
your
course.
witness.
It's leading.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dighton, correct? Being called out to Dighton, to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right? Do you remember the SUV?
Handsome gentleman with the tie. He walked back to where Karen Reed's father is in the courtroom, for those of you that are listening in the background, and walked back to where Karen Reed's father is sitting in the courtroom.
I do.
Do you remember the condition of the taillight?
I do.
So Jackson's going back to, but you remember that day, don't you? You remember that day.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dighton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD?
Well, right.
I'm sorry, in Canton, in the Sally Port, at the police station
I wasn't.
at 5:30 p.m.?
Objection.
Sustain.
At any point, did you ever go to the Sally Port
I mean, it was leading.
at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustain.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
I'm going to gain this back down because Jackson is at the microphone and is quite loud, and it is very loud. So if you notice a change in the audio, that's why.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Jackson's
Just to assist
leading.
another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
The reason those direct questions at the end weren't leading is because they are open-ended questions. Did you see Trooper Proctor take a photo? The answer isn't assumed. You saw Trooper Proctor take a photo. It's, did you see Trooper Proctor take a photo? Yes or no? Did you see Buchanan take a photo? Yes or no? That's why, even though they are short, succinct questions and yes/no questions, they aren't leading.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or
It's a
the
good
Commonwealth?
question.
The Commonwealth.
You testified for them?
Correct.
Objection. Move to strike.
So
They
that's
called you.
stricken. It's beyond the scope.
It's not beyond the scope because he asked who asked you that question. Brennan said, who asked you that question? And he said it was Attorney Lally. So it's not beyond the scope. He directly asked it, but who called you to testify? The Commonwealth. So who was asking you questions? Attorney Lally.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you
Good
on the
questions.
telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken.
So they never called you. They never reached out to you. They
You and I
never
met
followed up with
in
you.
a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Well, now he said the word
Did I introduce
nefarious.
myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Objection.
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Jackson got the information in before the
Did you
jury.
and
He
I
wanted to
ever
get in
speak,
either way.
ever,
You know I live in
before
Los
your
Angeles, don't
testimony
you?
last year?
No.
Yep.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barros, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
Do you remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
That's all.
And that's the end of redirect.
You would agree that your memory has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dighton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up. It was opened up.
Brennan has walked away again. I'm going to back up that next question because I didn't even hear what Brennan said. The defense objected and the court said it's been opened.
With your memory of what you saw in Dighton on January 29, 2022.
Objection.
I'm going to allow it.
I don't know what photo they're showing. I can only imagine that the photo is the photo from the Sally port based on his question asking, is that photo consistent?
In Dighton on January 29, 2022.
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set, sir.
Thank you.
Well, what photo were they showing? The photo from One Meadows? If it's the photo from One Meadows, he already said that that was consistent. We don't know what photo he was showing. So, a lot of you are saying you think it's the one from One Photos. I don't know. Let's back up and see if he makes it clear in his question, because Brennan's questions were hard to hear. I want to hear what photo it is. Because the recross was, you admit that your memory has changed, and this photo's consistent.
Has changed since
So I want to hear his last question one more time.
last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with
The photo that I showed you, the close-up with the missing right rear taillight. So that must have been One Meadows, because he didn't show him the photo from the Sally port.
your memory of what you saw in Dighton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
And he said, yes, it's consistent. So chat, you said One Meadows, yes. And the objection from the defense was assumes facts, not in evidence, because what Brennan said is the photo with the missing taillight, is that consistent? And he said yes. So it's not that the picture wasn't in evidence, it's the characterization of the picture that is a close-up of the missing taillight. The characterization is what the defense objected to. And the witness said, yes, that's consistent.
All right, Sergeant,
Or
you are all set.
Not the defense. The witness said, yes, this is consistent. The defense objected.
Thank you.
Quiet, please.
All right, so
End of the
jurors,
day,
I
I'm
know
sure.
I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witnesses. So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation.
And jury's out for the day.
Case, if you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day. We'll finish by 1. Okay? Thank you.
All right.
Did the court just say tomorrow's a half a day? The court did just say tomorrow's a half a day. Well, y'all, the court just did. She said they would be finished by 1. I'm going to be starting right on time tomorrow. Here's why. Because you know what I need to do tomorrow? I need to get on a plane. So I was only going to be able to cover a half day, and then I was going to have to take a break and then cover the rest of court later. But I have never been more excited. The jury is probably like, stop it. But I am thrilled. This works incredibly well for me. I'll be hotel streaming the next 2 days, and it will be very early because I am changing time zones. But nothing has ever worked better for my schedule. Emily, is it all about you? I mean, no, but also this is so incredibly convenient. The jury is going to be so annoyed that it's another half day, unless it is a half day for jury scheduling. And we saw that with another half day where the juror had an appointment that they could not miss. So it could be a half day based on jurors. It is also like graduation season. There could be a lot of reasons they're having a half day, and it might be juror seasons, not court season or court reasons. I'm going to see if they put the attorney stuff on the record before we summarize the end of today. Does the court have my schedule? No. But am I so incredibly excited? Yes. Is it just, it's kismet. It has lined up well. I am so excited. I'm sure it was planned. I just didn't know.
Eyes for the court, please.
But I appreciate it. It's going to make my life a lot easier. So, you know, my parents will be thrilled as I'm traveling for a birthday event. And we know shit pops off when I travel. Did you really just clear the courtroom to take them all to sidebar? Ugh.
No.
Are they going to put anything on the record?
Are you...
Ooh, okay. Let's back up a little bit. All right. I'm just waiting for them to go on the record at this point. I feel like I will zoom past it or zoom not past it or something. What is going on the
Court,
record?
please be seated.
So there have been some motions, I think, piling up.
There have been some motions. There have. But which motions are we going to talk about?
Two I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolokithas?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you...
The defense is calling Mrs. Kolokithas? That's an interesting choice.
Sure, I have time. I just don't know what you're talking about. Sure.
So they're talking about discovery motions and reciprocal discovery motions and motions to turn over information from the witnesses based on either the statements they made to defense, conversations they had for defense, etc.
3 issues that I believe we should dispatch with today.
All right, so why don't you... Sure, I have time. I just don't know what you're talking
So
about.
she's asking Yannetti because these are his witnesses. Laughlin is the tow truck driver. Karina Kolokithas, for all of you watching this trial for the first time, Laughlin is the tow truck driver. We saw him last time. They are talking about discovery as to him, and then Karina Kolokithas testified last time. I thought she was a great witness, though there were moments where I was like, why did the prosecution bother calling her? I mean, she was lovely, and she's like, my kids were giving me a hard time, so I went out with a group of people that I kind of loosely know, and the events of the evening, I was there with my husband, and I think she was probably the most sober one that was there. So, not tow truck, Plow, the Plow driver. Yes, it's been a long day. But I think my impression from last time is she was really the most sober one that was at the waterfall, and I'm interested to see what they are going to be asking. But Loughran, Plow driver, we will probably also hear from the tow truck driver, I would imagine. And then Karina Kolokithas, who was at the waterfall, who was called by the Commonwealth last time and not called this time.
The reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolokithas?
Yes, and there are 3 issues that I believe we should dispatch.
Oh, that's at my house.
All right, so why don't you... Sure, I have time. I just don't know what you're talking about. Sure.
Karina Kolokithas was at the waterfall, but they, I believe, went home after being the waterfall. So the court said, I have time. And the clerk is taking the banker's box out of the courtroom, and everyone approached at sidebar. Why at sidebar? Yannetti said sidebar. So I don't know if they'll put anything else on the record today, but we will see. I'm going to zoom. So we will see. It sounds like those are going to be the witnesses tomorrow, would be my guess if Yannetti says we need to discuss this now. Let's see. That's a lot of them not being on the record. I don't know if they go back on the record at all. All right, let's see if they do. I mean, even though we saw witnesses last time, what we've learned is that nothing is going to happen in a normal, orderly, or linear way. So seeing witnesses last trial means absolutely nothing at this point in this retrial, because who knows what's going to happen or what will be testified to, which is why I stick to what's in the court filings and what happens in court, because I don't know. We're going to see tomorrow. I think they are done for the day. Yep. Brennan grabbed his shit and was like, out for the day. Oh, went and got his bag. That's fair. Yeah, everyone's packing up for the day, including the court. It doesn't seem like they are going to put anything back on the record. And it does seem that Yannetti is sitting on the farthest right of the defense table, I think. From where Brennan was standing, then again, I can't really orient the courtroom very well, but Yannetti is the attorney on the far end where Alessi is sitting closer to the jury box. So who knows? But that is where we're at the end of the day. Jelly Bean said, do we think the jury will start deliberating before next Friday? No, not before next Friday, because the prosecution is going to have rebuttal witnesses, and then they have to do closing arguments. They still haven't had a jury instruction conference, which they're going to need to do. And we're getting into Wednesday, which is a half day. So no, I don't think we're going to see. The defense said they were going to be a week and a half, and then we're going to have a couple days, or at least a day, if not a couple days of redirection. So the Lauren, Google grabbed your question. I think your question is fine, but Google grabbed it. Her husband, that was not Karina Kolokithas' husband. That was the friend who was sending the texts saying, you know, come out to the bar. Let's see if we can summarize today. We're not going to see the rest of the motions, it seems. For those of you asking about the motions, we talked some about the motions yesterday. The court's not addressing the rest of the motions. The motions that seemed to have everyone in a tailspin yesterday were the missing witness instruction. It's a request for a jury instruction. That's within the discretion of the court. There is case law on it. There are factors that will need to be met for it, and they will probably need to argument, but that is a case law determination. It goes to, could this side have called a necessary witness? And did they? Could this side have called a witness? And there's a couple witnesses. I think that the defense can argue these were necessary witnesses and the Commonwealth didn't present them to you. But there's a jury instruction that goes to that. And so the defense is asking for argument so that they can discuss it before the jury. So that's what those motions are. We're not there yet. They're going to need to have a jury instruction conference. I don't know if she allowed that to be televised last trial. If it is, we'll cover it. If it's not a day when I'm on a plane, because jury instruction conferences are incredibly illuminating. I understand that they are also boring, but they are incredibly illuminating, and we will learn a lot from that. Let's try to wrap up today at the end of testimony before it all runs away from my brain, because today has been a lot. At the end of the day on day 26, first, we learned that tomorrow is a half day, and second, we finally got to the end of the testimony of Dr. Russell after much back and forth on recross and redirect, and then we got into defense witness number 5, Sergeant Barros from Dighton PD. At the end of the day, the testimony with Dr. Russell is really the kind of testimony that is going to give the jurors who are like, hey, there's reasonable explanations for how this happened, room to argue. And there are going to be jurors, or there could be jurors that said, I don't know how to parse this or that because so much spaghetti was thrown at the wall in both cross and direct. They got into methodology probably more than the jurors ever wanted to hear. It matters to set up the battle of the experts with the rebuttal witnesses. But there were times in cross when Brennan was wandering into, but you can't determine that. And she's like, well, I've been an ER doctor. So I've been an ER doctor, so I can testify about injuries I've seen and wounds that I've seen. My criticism of the cross-examination for the Commonwealth is that they continued to throw out alternate theories instead of trying to narrow the witness down on why those injuries from their perspective came from a vehicle, not a dog. So getting into, but you can't tell if it's this or this or this or this or this, I don't think helps the prosecution move their case forward with that expert witness. They spent a significant amount of time saying, well, you can't determine if this is teeth or claws, and you can't determine this. And this article doesn't say what you say that it does. And we saw Brennan trying to really fight the knowledge base of the expert on, but this article says there's these factors and those factors aren't here. And she said, right, there aren't those factors in this case. They don't have to be in every case. I think what's difficult in the way Brennan cross-examines is instead of saying, so this article is something you rely on. This article says there needs to be these factors, punctures, tears, and those weren't here. He says, well, this article doesn't even lay out a standard. And then she says, I agree, there's different ways to approach this, but it's all pattern recognition. These articles show that you need to consider all of the injuries together. He said, so this doesn't even establish anything. And then he relies on the article to try to say, but these things aren't here. Pick one, and it might have more impact on cross. And I think it would have had more impact for him if he said, these articles you rely on say these things, puncture wounds to the skin, tearing, these things need to be present. I think she would have answered, no, they in extreme cases, which these were because they were deaths, but it would have at least helped, I think, Brennan make his point. We'll see. Again, the takeaway for the jury will be that there is an expert who says that the injuries to John O'Keefe's arm happened by a dog bite. And there is an expert for the Commonwealth that says that those happened from a taillight. I think the point that was difficult to follow for me the most from Brennan is when he was getting into the small and seen under magnification and microscope pieces of debris that were taken out of John O'Keefe's hoodie and shirt, and asking about whether those could have caused the injury to John O'Keefe's arm. I'm like, where are we in this questioning right now? And Dr. Russell kept saying, but those wouldn't create linear, parallel injuries. And he's like, but there was all this debris. What in the world? So there was some rough cross-examination, I think, from Brennan. However, my opinion on that is different when it comes to Nicholas Barros. Nicholas Barros was from Dighton PD. He responded to Karen Reed's father's home when Proctor and Trooper Buchanan arrived at Karen Reed's parents' home to seize or take possession of Karen Reed's SUV. And they had called, Barros, they had called Dighton PD around 2:30 in the afternoon on January 29th, 2022, and said that they were coming to Dighton to take that black SUV, and said as early as 2:30 p.m., this SUV was involved in a homicide, and we are coming to take that SUV. And then reiterated that when they called around 3 and said that they were almost there. And then when Barros arrived at Karen Reed's parents' residence, where we see that camera angle of the Lexus being loaded onto the tow truck, he arrived. Trooper Buchanan and former Trooper Proctor were still in a personal vehicle truck, and he met them there. They identified themselves. He spoke with Karen Reed's mother. He talked about being around the Lexus for at least about 20 minutes and observing the back of the Lexus. He talks about writing a report and then seeing damage to the rear of the Lexus where the taillight was cracked and a piece was missing, but not completely damaged. He said it was about I think a dollar bill size damage, and then demonstrated the size piece that was missing out of the taillight. So cracked and a piece missing, but not entirely damaged. He was shown video by the defense of the vehicle being loaded onto the tow truck and said that looks consistent. And then he was shown video from the Sally port and said that taillight in the Sally port is completely broken out or completely busted out. And that's not consistent with what I saw. In his cross-examination, I think Hank Brennan made some headway on this witness's memory. I do think that the point that they were referring to that being involved in a homicide investigation as of 2:30 p.m. is very interesting, especially when you have the coroner saying that they couldn't determine that that was a homicide. That timing I don't remember from the last trial, and that stuck out to me quite notably that they used that word with him based on his testimony. As we get into cross, I think Brennan made headway with that witness that will discount him for some. Brennan said, that's not what you testified to last time. You didn't say it was cracked with a piece missing and describe the piece missing, and you didn't describe how it was different from the picture in the Sally port is what he seemed to be referring to. And the witness said, I did distinguish between what I saw at Karen Reed's parents' house and that photo. And Brennan showed him the transcript and said, where in it do you distinguish between the two? And he said, it's not in there. And then Brennan went down a line of questioning saying, so your memory isn't perfect as to what you testified to last time, and you don't remember if you distinguish the two, and your report is scant on the issue of it being cracked versus damaged. And then Brennan showed him the ring video, the ring video from 507, and then the photo from One Meadows that comes from the dash cam, and says, can you zoom in? Do you see that? Do you see that break? And do you see that picture? Isn't that consistent with what you saw? And he's like, yes. And I think a lot of the chat was like, they're the same picture. What are we talking about? But Brennan says that and I think asked well, wasn't the back of the Lexus SUV covered in snow? Wasn't snow packed into the taillight? So you couldn't have seen if it was missing. And the witness agreed with him. And then we got into a whole line of questioning about, but you met with the defense attorneys, you met with them at a hotel. Isn't that weird that you met with them at a hotel? And the witness was like, we met in a conference room at a hotel. It wasn't weird to me. But the witness gave a lot of ground in the answering of his questions. I think some will see the witness as being incredibly forthcoming. Yeah, it's possible. I don't live under a rock. I've seen these clips all over social media. I've seen that tow truck video. I've seen the ring camera video. I've seen them more times than I can count. Some will be like, yeah, he was really forthcoming. He left open the possibility that maybe his memory was impacted by the things he's seen about this case on social media. And that's why he is now describing the missing piece of taillight different. Some might discount him entirely and say, well, you were very certain, and now your testimony is changing after you met with defense attorneys. Isn't that strange? You met with defense attorneys, and now you're like, no, it's a bigger one, and no, it's this, and no, it's that. It's really going to depend, at this point in trial, it depends on how people see the evidence coming in. Because we have gotten 26 days in, and it really depends how people are seeing the evidence. And I think you're going to see the exact same witnesses argued different ways. Because when we see Alan Jackson get back up in redirect, he says, okay, well, you had a birthday 2 years ago. What day of the week was that on? Oh, you don't remember? Would you say you have memory problems? No? Okay. Do you remember being in Dighton? Do you remember seeing the car? Does it look like what was in the tow truck video and not what was in the Sallyport video? Okay, that's what you remember. And Brennan got up at the end, and it seems that he asked about the One Meadows Ave photo and said, but isn't that consistent with what you saw? No, that's not exactly what Brennan said. Brennan got objected to because he said, isn't that photo with the broken taillight the same that you saw. And that would be the dash cam video, I think, because we didn't see it on screen. The dash cam video with the snow packed in to the taillight. That's how Brennan presented that. But will it matter? Because what we have is the tow truck video, the Sally Port photo, the video from 5:07 a.m. leaving One Meadows Ave, and then the photo from the dash cam at One Meadows Ave, and the jury can look at all of those themselves. So at the end of the day, you have someone who is in Dighton saying it was the same to me. The Commonwealth hasn't talked to me since the last trial. The Commonwealth hasn't called me. The Commonwealth hasn't asked me any questions. And the jury can see it for themselves. Because what he said was, it was cracked with a piece missing. But Brennan's cross-examination made him doubt his testimony, and he backed off of his testimony quite a lot. We will see what impact that has. Or is it just helpful to bring all those pictures up at the same time and let the jury see it for themselves? Here's the tow truck video. Here's a zoom in of the tow truck video. Here's the picture from the Sally Port. Here's the picture from One Meadows at 5:07 a.m. Here's the dash cam, putting them back to back to back to back. Is the jury seeing it for themselves more helpful than this witness's testimony? And is that really the point? That they've now seen all of those in sequential order? We will see. I would love to know your thoughts on it. I think how people read Barros' testimony is really going to depend on how they see this case. Just 100%. It's going to be all based on how do you see this case? But I'm sure that Brennan was very happy with how that cross went. I don't think Jackson was as happy with how that cross went. I think he did a lot to say, this is all silly in his redirect. It might land for some. So we're going to have to see. But tomorrow's a half day. I'm going to answer some questions. Law nerds, it's been a long day, hasn't it? Let's get to some questions. I've seen a number of you ask, Emily, why does it sound like there are lawn things happening outside? Right, because no matter how much I have conversations about the fact that I'm covering trial, the lawn things still happen at unpredictable times, because it is that time. That is that time when well, the lawn starts to grow quite a lot. We've had a lot of rain. So yes, that's on my end, not your end. So Lindsay says, I'm so confused. Which photo are they talking about? I think, and that's why we backed it up to listen to it. I think Brennan's description was the One Meadows Ave photo, because he said, I zoomed in, the photo I zoomed in on with the snow. So I think it is the dash cam. Emily, why don't you just zoom backwards and pull up that photo? It's not like you don't have the feed still pulled up. Hold on. Let's pull up the photo, I think. And again, this is, I think, what he described. He talked about the close-up. I think they are describing this dash cam photo from One Meadows. So I'm going to see if he zooms in on this more. I'm going to mute them talking. I don't know if he zooms in on this more or not, but this is, I think, the photo he's talking about from One Meadows. Let's see. Did he zoom in on this initially when he put it in? Yeah. So I backed up a little bit. Brennan is showing this to the witness. I muted it because we've gone over this, but Brennan does, what I wanted to see is if he zooms in on it. Brennan zooms in on this. I think this is the photo. I think this is the photo. So let's see. Yeah. I think that's the only one who zoomed in. I think that's the photo that he's talking about. A lot of you were like, I think that's the photo that he's talking about. I think that's the photo that he's talking about. But he didn't clarify. What he said was the photo I zoomed in on, and then we couldn't see if Brennan was, here we can hear his question one more time. We didn't see the photo. So, let's see. It still doesn't look like the Sally Port, and this was before the tow. Kathy's, yes, that photo is from One Meadows Ave when they went out in the morning. Let's see if this is where Brennan's asking him about that.
Willingness to testify.
No, that is defense questioning. I just wanted to get to that last question from Brennan because it was pretty quick.
29, 2022.
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
All right, I'm going to back up again because there was all the objections, and Brennan's hard to hear, but this is the question he asked.
Has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dighton on January 29, 2022?
Objection.
I'm going to allow it. It was opened.
The objection was to the word missing, like I said previously, but the photo I zoomed in on, I think he means that dash cam photo. So that's what I think. So we'll see. Again, Brennan is going to argue that the snow accumulated on the taillight shows that the taillight is missing and that snow is accumulated in the gap, if you would, or in the void. But one of the things in that photo that's helpful that we don't have in a lot of these photos is you have both taillights side by side. And the jury will get to look at these when they go back in the jury room and decide if things look symmetrical on both sides. And we're looking at the One Meadows Ave dash cam photo. If those look symmetrical or different, if the snow looks equally packed on to the taillights or different, if it looks like there is a void on the passenger side or not. So that I think is the video that he was talking about. So with all of it, we're going to get to some more questions. It was a long day. It was a long day. It was a long, long day of court. So, Margaret in the chat said, I hate hearing the word snow in June. I know it is definitely it is starting to get warm. And Dan in the chat asked, when was that picture taken? It is a still from the dash cam video. And this happened maybe the first week of trial, maybe the second week of trial. And it was when they went out to check on John O'Keefe's niece and nephew. So it was after 7 o'clock in the morning, 8 o'clock in the morning, because it's already light out. So I remember they time-stamped it, but it is before Karen Reed gets back to One Meadows Avenue from the hospital. So it is in that gap between when it gets light. So after 8 a.m., but I don't remember exactly. Before Karen Reed gets back to One Meadows Avenue later in the day. So that is when the dash cam, like it came in and the dash cam caught that, but they were there for different purposes. They weren't even there paying attention to the car. They were there because they thought John O'Keefe's niece and nephew were home alone. John O'Keefe was at the hospital, I think had been declared by that point. Karen Reed had been put on a psych hold and hadn't been released at that point. So there were no adults that were at the house at that time. And law enforcement did not know whether or not John O'Keefe's niece and nephew were at the home by themselves while all this was going on. So they went to go check. The friends of John O'Keefe had already gone to the home to collect the niece and nephew. We don't have a lot of testimony about that this trial. So that is around what time, but it's clearly getting to be daylight. It's not as dark as it was at 6:30, because the video when everyone arrives at 34 Fairview is very clearly like dark. Winter, sun's not up yet, pitch black. So this is well enough after that. Okay. Let's continue on with questions. And I've seen a lot of you ask, is the photo doctored? Is the photo this? Is the photo that? There would be arguments by the defense of that. There would be arguments over letting it into evidence of that. None of that's in evidence, so I have no speculation on it. This is from the dash cam. They haven't argued that it's not from the dash cam. We've seen the video from the dash cam. So that's where I'm at on the video from the dash cam. Everyone who gifted memberships, thank you. Again, sorry for the loudness outside my window. I have literally no control over it at that point. Anna asked, do you think having a younger jury will make a difference? Yes, especially when it comes to some of the tech evidence and tolerance, sometimes tolerance for nonsense, but we'll see. It really just depends on the individual jurors, not necessarily their age, but there's a lot of tech in this trial, and there's some tech that timestamps things. And do those timelines shift? Do those timelines not shift? Where are those timelines? I think that can be important for people to understand tech and not just discount that information. Mary said, will Fred be traveling with you? No, Fred has a friend that will be coming to hang out with him and George. That is so loud. Apologies, Hat. It should be done at some point. Jessica asked if they make headway with this witness, does it help any at this point? Barros's testimony is going to go to how people see the evidence already. So does it make a lot of headway for one side or the other? The Commonwealth is going to argue, see, he talked to the defense attorney. I mean, if they even argue Barros's testimony, this is what they were trying to show in their cross. See, he talked to the defense and now his testimony has changed. That's not how I read his testimony from when he said, I think if I was asked that, I pointed out the differences. But for those that are like, see, these defense attorneys are trying to pull one over on you, they're trying to trick you, then they're going to say, see, he talked to the defense attorneys, his testimony changed, his memory's been impacted by social media. And others will say, okay, but what he said looks like what's in the videos. So does it matter? It's really going to depend on how the other evidence is seen. And it's going to be taken in totality. Do I think Officer Barros's testimony changes the case one way or another? No, it's argument points for how people already see the case at this point. And that's what it is. Again, because the jury can take a look at the videos and they're going to say, well, I see this. So that's how I see it. But I'm going to point out if the attorney makes headway in cross-examination where the witness either shifts their testimony, agrees with the prosecution, their confidence changes, we're going to talk about it 100%. And that demeanor of the witness shifted. From the time I said, look, this is what I appreciate in a law enforcement witness, he was saying, yes, no, just answering the questions. And then it started to shift. Like, his cross completely shifted. His confidence shifted. The way that he testified shifted. And he started to agree with Brennan. Yeah, that could have impacted my memory. Yeah, that could have done this. So Brennan was able to make that shift. And we're absolutely going to talk about it. Because Brennan was able to shift his confidence in it. And that's what I saw as he was testifying. Sheila said, do statements made to the Commonwealth have client privilege? No. The Commonwealth doesn't have clients. So if a witness has a meeting with the prosecution, there generally should be multiple people in the meeting. Oftentimes it is a prosecutor and at least someone from law enforcement. And there would be a memorialization of that meeting, and it would break down what happened at that meeting, what was said, what was asked, and what happened. And then that would be turned over to the defense as a witness statement. So there's no client privilege because the Commonwealth doesn't have clients. The client is the people, in this case, the people of the Commonwealth, and not an individual. The defense, their client is Karen Reed. So their privilege as to their client, Karen Reed, is an entirely different thing. It's a good question. Thank you for asking. I'm getting to some other questions for the chat. We'll get through some super chats, and then we will go from there. Let's see. That's the outside. How much longer, the Lauren said, with this trial? Well, the defense said they had 1 to 1.5 weeks. They are what, 3 days in? So I would expect 7 to 8 days of the defense case, maybe less. We're 3 days in. Tomorrow will be a half day. So we have at least another, this week and next week, we're going to go at least into 8 weeks. And then I don't know how long the Commonwealth's rebuttal will be. 1 or 2 witnesses? That's going to take some time. So yeah, at least the rest of this week and all of next week at a minimum. I will have more information the more we see how the defense witnesses come in. But I think we're getting further and further away from the defense calling Higgins, Proctor, anyone named Albert. I think the defense has really moved towards just sticking with the investigation and arguing over the investigation. So that's where I think they're leaning. I agree with that strategy. I think trying to say everyone is involved in a conspiracy is difficult. I also think that it tempts the jury to say, well, you haven't proven that to me yet. And I think saying, look, this investigation didn't follow this. I think it is a better argument for the defense and the Commonwealth. It really has to narrow down how they think this happened. That is going to be their biggest hurdle in all of this, is how do you narrow down from what their experts have testified? How do you narrow down that there is only one possibility in this case? And that's what they have to do in their case in chief, in their rebuttal, and before closing. So Anna said it would have been better if he said, my wife loves crime cases, sir. Do you have a wife? Does she enjoy serial killers and documentaries? So yes, I've seen the video thanks to her algorithm. I think Barros was really upfront with the way that he answered things. I think his answers damaged his testimony, but again, it's really going to depend on how people view the case already. But he was forthcoming with his answer going, yeah, I do think that's possible. Now, we've heard 2 witnesses say, I don't live under a rock. It's impossible. It's impossible to avoid this case on social media. 2 witnesses. Wild. Wild. The Lauren in the chat said, I'm glad the kids didn't have to testify. They did. They testified earlier in the case, and they did not testify in a way that was televised. It was just written, but they did testify. I can explain why the defense does not get a rebuttal. It's because the Commonwealth bears the burden. So the burden of beyond a reasonable doubt rests on the Commonwealth, and it is because of that burden that they can have the first word and the last word. It's the same with closing arguments. The prosecution gets their closing, the defense gets a closing, and the Commonwealth gets a rebuttal. It is because they have the burden of proof. It's a great question. Thank you. Shay said, can't go online in Massachusetts without seeing this case. Barros. Yeah. The second time it's happened in 2 days of, yeah, I don't live under a rock. You see things in this case. T.S. Tolkien said, video of the Lexus on the tow truck with fully intact right rear light makes all from Commonwealth mute. I see the brake in the taillight on the tow truck video, but I also see where they are saying there is much more intact taillight in this video than there is in the Sally port. I see where the brake is, but the brake in that video to me does not look the same as the Sally port video. So M said, off topic, why are you not covering Lively? I have covered it in the podcast, but there's like 800 or 900 pages of documents I'm behind on, and I'm covering this trial. And that takes a ton of energy and time. So I truly don't have time at the moment to catch up on all the documents. We'll catch up at some point, but it's been on the Emily Show podcast. So if you're tuning into the Emily Show podcast, it's there. Also, every time I poll our community and say, do you want more coverage of this? The resounding answer is no. So it's getting updates in the Emily Show podcast on the Emily Show channel because of that. Because every time I say, do you want to cover this more? The resounding polling response is nope, nope, nope. I do not want more. Do not want more of that. So I've kept it to the podcast for now. We will get, when I get caught up after this trial, we will get there. It's just really going to depend on time, but that case is years away from trial. And while covering this, I do not have time to stay up on all of the documents. And those lawyers are just prolific in writing out motions. So when I say I am hundreds of pages behind, it's because I'm hundreds of pages behind. And I cover cases from the court documents, so I don't read summaries of the documents from the media. I want to read the documents myself, and I just have not had time. So we'll get back to it at some point. The updates live on the Emily shows. I can get to them. I've just repeated myself like 7 times. Shaylee said, because this is talking about Karina Kolokithas, because she said to her husband, why can't we be more like them regarding their PDA? I wonder also if it's because she is one of the most sober that was there, but I felt her testimony when she's like, my kids were giving me a hard time saying, you never go out, go meet dad, have a drink. And she's like, I had already gotten home. I had already changed out of my work clothes. It had been a long day. What I didn't want to do is leave my house again. And I was just like, 100%. Like 100%. We feel you. So I'm interested to see where that testimony goes. But yes, she did testify to the affection between John and Karen. I do remember that. Why do you think the defense is reluctant to call Proctor? Katrina asked in the chat. I've been thinking about this because, again, I have said regularly, I think it's a no-lose for them. But a couple of you in the comments, and this is what I love about getting to have a conversation about the law. Anytime I see, oh my God, Emily, come on, WTF, this is so XYZ, my brain just stops. But I saw some of the comments saying, hey, don't you think that Proctor becomes a loose cannon because he has nothing else to lose? And I was like, hey, that's a really excellent point. So I'm always up for a conversation. And I think it's a really excellent point that a number of you made in the chat and a number of you made in the comments. Proctor has nothing to lose. So Proctor's been fired. Proctor doesn't give a fuck, my assumption at this point, because he's been fired. So Proctor could try to throw a grenade into this case by saying whatever. Like, what else is going to happen to him? What else is going to happen to Proctor? So I understand that might make the defense hesitant to call Proctor because he has been fired, because he has nothing left. Well, I would suspect that because he doesn't have a lot to lose and because he's an unknown. So I don't think it's a unfair consideration. And I think the defense would absolutely have hesitancy that he is such a loose cannon. I think that's a fair hesitancy for the defense to have. And we've seen how Brennan approaches Cross, right? We've seen Brennan, and we heard it from Yannetti, we've seen Brennan try to lead through his closing argument. So that's going to be interesting. Katrina said, great point. Proctor has scores to settle. Makes sense. And then Kel in the chat said, doesn't Proctor need to find a new job? Yes, but I don't know what that's going to be. Mary Kate said, I thought he was appealing his firing. I'm sure he will appeal his firing, but he has been terminated at this point. And maybe appealing it, he doesn't have as much of a I don't give a fuck, but he is a loose cannon. Mixter in the chat said, EDB, is or are there specific witness or witnesses that stand out to you in this retrial so far? Oh, I would have to think about it, because right now it's just going to be recency. It's going to be 100% recency bias to what stands out to me. Because today and yesterday have been so wild, I would have to take a step back. And I'm also, the thing that's hard is what will stand out to me this trial will be very different than last trial, because there's things I heard before. Last trial, I was like, red solo cups, what? These text messages, what? The strategy is very interesting to me this trial. And I think what stands out to me the most, to not recency bias the whole thing, because yesterday was so freaking wild, who the Commonwealth chose not to call right now is what is standing out the most. Like, being able to rattle off all the people not called is wild to me. So when I'm comparing the two, I think it's really the lack of witnesses, really, because that's a lot. Miss Dever was an interesting witness. Was an interesting witness. Natalia and a number of you asked, why do they all go to sidebar lawyers and Karen? Is that normal? It is normal in this court for this case. In other courts, you will see the defendants have headphones so they can listen to what's happening at sidebar. The defense asked for that this case and said, can we just have headphones so she can hear what's happening? And the court said, no, she can come up to sidebar. So she goes up to sidebar. So yes, for this, it's normal. Does that happen in every other case? No. But also, I think the defense asked for headphones because of how small this courtroom is. I mean, this courtroom is small. And I suspect, and this is my supposition, I completely suspect that the defense was concerned about what those in the gallery sitting near to their table could hear or overhear if they were trying to catch Karen up on what was happening at sidebar, because she has a right to know what's happening at sidebar. And some pretty big decisions get made at sidebar in this case. So she has a right to know those decisions. And if her attorneys can't catch her up on that easily, then they needed another solution, and the court would not give her headphones. So everybody goes up to sidebar. And as we've learned, a lot happens at sidebar. We've not seen them. They're all impounded. We can't go get the transcripts of them, but a lot happens. M. Royal said, do you think the jury will like this kind of snarky questioning from Brennan? It really depends on how they see the witness, because snark for one witness is not the same as snark for another witness. So it depends on the witness. If Jackson's getting snarky with Officer Diva, then that might resonate a little differently, because she came out of the gate pretty snarky with him. But when you have an attorney getting snarky with a witness that they haven't earned it on, and I think I've said that a couple times, like, you haven't earned your snark with this witness, with a witness that's being forthcoming and a witness that's been linear and is not fighting with the attorney, the snark can be too heavy. And I think we saw that most recently. We've seen that at other points in trial, because I said it of the defense too, but we saw that most recently with the first witness for the defense, the engineer. The engineer said, in cross, he was agreeing a lot with what Brennan was saying, and Brennan was getting more and more agitated. And the witness is like, no, I agree with that. No, I agree with that. And it's like, there's a horrible disconnect here. So it depends on how the jury feels about the witness. Because Brennan was not snarky with Dr. Russell the first part of cross, and then came out of the gates hot this morning. And she also had changed the way she was answering him this morning, which doesn't surprise me after well, it's not in the report. So dynamics can also change. I think at times it can be too strong from both sides. I don't know if I've said Alessi's snark has been too strong, but I think just about everybody else, I've said the snark is too much. Maybe not Lally. Lally and Alessi might be the two where I'm like, that snark is too much. They might be the two where I didn't say it. Everyone else at some point I've been like, that is too much. Because when you're in trial, you've got to make sure that you are not trying to just win the moment. And we've seen a couple witnesses that wanted to just win at the game of cross-examination. Whew. Steven said, don't they have reports that weren't written down for 400 plus days? He needs to sit down. Right, because the jury's not going to forget that either. I think the oldest one was like 500 days. Melanie said, Yannetti hasn't been too snarky this trial. That's fair. And Ted said, Lally doesn't have snark. Yeah, and right? There's a history to the things that Brennan is now asking in front of the jury. Like, oh, your report was scant. How many of you put in the chat, well, there is a report at least. And that's what's difficult. Because he keeps bringing things up. And the same is true for him. It's a real interesting tactic on cross. He is just trying so hard to insinuate things that the same can be said of his own witnesses. It's spicy. No, I don't think so. Mama Deadhead said, objectively, Yannetti and Alessi are hot, confirmed. It's apparently on the record now that somebody is the attractive gentleman on the counsel table. Drama Llama said, Brennan cannot possibly think the jury won't notice that he wants everything both ways. It's become quite consistent that Brennan wants to have everything both ways. So let's see. Hannah asked, was there clear glass on the bumper? There was clear glass on the bumper. Where that clear glass came from has oh, no, you're asking it a different way. Hannah, that's a really great question. Did he remember clear glass on the bumper? I think the answer would be it was too covered in snow. But they didn't ask that for anyone. But that's a good point. For sure. Let's see. We have Ford F-150s in South Carolina as police vehicles. Yes, I just thought it was funny because being from most of my life and career, Los Angeles, and Jackson being from Los Angeles, we both said at the exact same time, you have a Ford F-150? Really? That's cool. Because it's so different. Again, jurisdiction by jurisdiction, things are so different. That's one of the highlights. Lona asked EDB, how would the defense have found out about this? I grabbed this because I thought it was a great question. I don't remember what time in the testimony we were when I grabbed this, but here's why I think I grabbed it. So if it is misaligned with the question, apologies. When witnesses give statements to the defense or the prosecution, the court has ordered that those be turned over. They generally are turned over in reciprocal discovery, especially if they're written communications. The court ordered the defense to distill any verbal communications to a written memorialization and turn it over. So the fact that a witness met with an attorney, those would be turned over. I think when it came to Alessi speaking with Dr. Russell, that was a normal line of questioning that Brennan was going to go down. And then her answer led to the rest of his questioning. So let's see. Tamara, this is very helpful. I don't think this was made clear in the testimony. I'm sure we will see it come up again, but Tamara said a scissor bite is how the teeth fit together. Most breeds have scissor bites. It's not the act of biting. GSDs have scissor bites, bulldogs don't. So the teeth overlap more like a scissor instead of the teeth hitting flat. Hopefully I'm interpreting that correctly, because I've only got one type of skull with the teeth hitting flat most of the time, though Dr. B would take issue with me and say, no, the front teeth actually don't hit flat. Those go a bit under. It's the back teeth that fit flat together and hit flat together, not overlapping. But yes, fair enough. And I appreciate it because I think Brennan confused himself during some of that questioning, truly. All right. I'm going to get to 2 more questions. If I did not get to questions, I apologize because the mower is about to come back round and I have tormented all of your ears enough because it is quite loud. Tomorrow, half day in court. I will be starting closer in time. I will also probably be pausing a bit less because I need to stop close to real time tomorrow. We'll see how that goes. We're optimistic. Oh, I did not I did not differentiate with the dogs, the GSD German Shepherd dog. Apologies. We have not gotten to the end of discussions about dogs and dog teeth and dog bites and dog this and this and this and this. But I will be here tomorrow for the half day and we will have a half day in court tomorrow. So, no, all of you are saying don't jinx yourself. I'm just giving my optimism, and also letting you know, because tomorrow somebody inevitably will say, girl, you're talking too much. Girl, you're not talking enough. Girl, are you tired? You're not talking. We've said Emily's got travel. We're going to try to keep it on time tomorrow. Fingers crossed. But the one thing we can rely on is when court says it's a half day, it's gonna be a fucking half day. That we can take to the bank. That we can rely on, and that we know is going to happen. So to all of you, thank you for being here. Thank you for making this the #1 place to watch live trials. I appreciate it. It was so good to see all of you in the chat today. Today was so much. How are the last few days so much? How is it so much? I don't know either. I really don't at this point. My expectations of, a retrial is kind of just retrotting the same ground with slightly different strategy. Wrong. Just wrong. Where
survey says
just wrong. So wrong. Continuously wrong. Because every single day I am surprised by what happens in this case. And I think that's why we're all here together, because you never know what's going to pop off in a case. And if you don't want to miss a thing, make sure you get the Law Nerd app, because we will let you know when shit pops off in court. I will see you in court tomorrow morning, y'all. I'm going to be a bit earlier, so we will see you then. Bye. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.